Good morning and welcome to this year's Symposium. My name is Maitreya Badami. I have the privilege of being the editor-in-chief for Santa Clara's Law Review, Volume 64. Thank you all very much for coming. It's so nice to see so many of you. And on behalf of the Law Review, it really is my honor to welcome this esteemed group of scholars and practitioners, to hear perspectives on today's topic, the California Racial Justice Act. Before I hand things off, I do want to make a quick acknowledgement that Santa Clara University sits on the land of the Ohlone and Mo'okwa Ohlone people. We remember their continued connection to this region and give thanks to them for allowing us to live and work, learn, and pray here on their traditional homeland. We offer our respect to their elders and all the Ohlone people, past and present. Now I would like to take a moment and recognize our incredible senior symposium editor, Chelsea Jordan. Today would not have been possible without all of her efforts over the past year. And please join me in welcoming her as we begin today's discussions.
Good morning, everyone. As Matteo said, I'm the senior symposium editor. I wanted to thank all of you for coming out today. But before we started, I wanted to express my sincere appreciation to all the speakers and moderators and the Heafey Foundation, Professor Polden, the Center for Social Justice, and the NCIP for helping me plan and fund this event. But I particularly want to thank Todd Fries, Carla Spain, and Sarah Pace from NCIP because they really helped me stay sane during this process. And before I hand this over to Lisa Romo, there's some housekeeping things that I want to go over. So first, if you want to have NCIP credits, their QR code is on the registration table. That will give you information about how to sign up and download your certificate. And then each panel will have about 10 minutes after for a break for you to go to the bathroom, do anything you need to do. And then there will be so for each panel, each presenter will speak for about 10 minutes. Then there will be questions from the moderator, and then there will be time for you also to ask questions. There will be a mic on each side of the room, over here and over there, that you can come down to. And also the bathrooms, if you haven't found them yet, is near the compost sign. So also let me know if you still can't figure out where that is. And then lastly, the lunch will be in the lobby, which you just came from, and we will have keynote speakers over the lunch. So next, we're going to hear from Lisa Romo, who's going to explain the RJA and what's happening on the ground since it has passed. So please help me welcome her.
Thanks and good morning, everybody. Is it okay if I sit down? Can you just see me? Or should I stand up?
It's hard to see you, Lisa.
All right, I'll stand up. Then it's hard for me to read, but that's okay. So I'm Lisa Romo. I'm from the Office of the State Public Defender in Oakland, and I work in our Indigent Defense Improvement Division, where I'm the racial justice attorney. I got started in this looking at racial disparities in the death penalty, and then the RJA passed. So I kind of moved over into our new unit, and this is what I do 24/7. I'm very fortunate to be in this position. So Chelsea asked me to give an overview of the RJA, and before I do that, I want to start with one global comment, which is we are seeing really great progress so far, and you'll hear from speakers today about the claims that they've raised and the claims that they've won. But I want to caution that it's really just the tip of the iceberg. I mean, we have a lot of work to do. This is a long-term project. And I think that one of the reasons that we haven't seen faster progress is because there's a lack of understanding among the participants, among defense counsel, among prosecutors, among courts, and others, about a couple of things. One, the RJA statute itself, it's complicated. People don't know how to apply it. But also I think about the problem that it was designed to address. So moving beyond explicit bias into implicit bias, into systemic and institutional bias and disparities, I think there's a lot of education that needs to be done, and that's why I'm so very grateful for Chelsea for organizing this great event. I think that will go a long way to help people learn more about the RJA. So with that, I will start with the heart of the RJA, which is 745A, Penal Code Section 745A. The state shall not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. So it seems simple enough, but if you've been in the trenches, you know that it's getting a little confusing. So it is composed of 4 different pathways, but it's a holistic statute that creates a broad scheme, and it covers every stage of the prosecutorial process, from investigation to charging to conviction and to sentencing. And so these pathways, which I'll address in just a second, 1 through 4, are not individual violations. They can all combine and work in tandem to create a violation under A. And there's a lot of great language about this. This language on the slide is taken from the Young decision, which many of you know is the first opinion that we had construing the RJA. So these pathways start with A1, out-of-court bias. This concerns the judge, an attorney, a law enforcement officer, an expert witness, or a juror who exhibits bias or animus toward the defendant because of his or her race, ethnicity, or national origin. And today I'll mostly say race as a shorthand for these 3 things. So I wanted to give you some examples of these different pathways. So I think it helps to understand the language when you see a real world example. So a couple that happened in the trial court. This is the Johnson case that was in LA Superior Court. The investigating officer engaged in a racist rant at a bar. They after court proceedings, they all went to a bar, and he said a bunch of very derogatory, racially derogatory things about Mr. Johnson, who had just been arraigned on additional charges. When that came to light, the trial court dismissed all of the special circumstance allegations in that case. Another that you may have heard about because it made the news is the Buggs case out of Orange County. So Mr. Buggs was charged with murder, and the question was whether he should be capitally prosecuted, whether the Orange County DA was going to seek death in the case. And so in an internal office meeting, the head DA, Spitzer, asked about the race of Mr. Buggs' former girlfriends and said that he knows many Black people who enhance their status by only dating white women. Through a crazy set of circumstances that I won't go into, this came out, and the trial court found that it was a violation of the RJA. So the first one, I think we can all agree with explicit bias, and the second one is really about implicit bias. So we're not looking for any intention. No one is saying that Mr. Spitzer intentionally was racist or biased against the client, but that his remarks expressed explicit bias. And so, implicit bias. So for the first time, those kinds of claims are actionable. And I will talk about the outcome in Buggs in a slide that's coming up. So very similar to A1 is A2, in-court bias. So this is things that happen during trial and in court, the same group of actors using either racially discriminatory language about the defendant's race or otherwise exhibiting bias or animus towards a defendant, whether or not purposeful. So this is about what goes on in the courtroom. I have an example here, People versus Simmons. This is a published case. So in the Simmons case, Mr. Simmons, as I gather from reading the opinion, is a light-skinned Black man. And the DA was asking about and he testified in his own trial. And so when the DA was cross-examining him, he started asking about his skin color. And he asked whether people mistook him for something other than Black because of his light skin. And he said that, yes, that frequently happened. And so in argument, the DA said that Mr. Simmons had been bragging about fooling women with his good looks, and he admitted to having an ambiguous ethnic presentation, and that people who did not know him think he's something other than Black. So when this got to the Court of Appeal, they found that this was an A2 violation and said that equating Mr. Simmons' skin tone and ethnic presentation with deception was a violation, because basically the DA was implying that he was not a credible witness because the color of his skin fooled women and confused strangers. So then we get to disparity claims, A3 and A4. And I would say there has been, some success with the A1 and A2 claims. They're a little easier to understand. There have been some difficulties with remedies, which I'll talk about in a minute. But A3 and A4 claims really have caused a lot of confusion and litigation. So A3 is when there are disparities in charging and conviction, and those disparities are based on the defendant's race. And then A4A is when there are disparities in sentencing based on the defendant race. And then we also have A4B, which are also disparities in sentencing, but based on the victim race. So we also have this language that there's actually a lot of language, and I couldn't put it all in the slides and talk about it because that would take us most of the day. The rest of the language about how you operationalize these violations, but basically it boils down to this is A3. The defendant was charged or convicted of a more serious offense than defendants of other races who have engaged in similar conduct and are similarly situated. And as I'll discuss a little bit more in a moment, the similar conduct and the similarly situated is really causing a lot of trouble. And then also the evidence has to establish that the DA, the prosecutor, more frequently sought or obtained convictions for more serious offenses against people who share the defendant's race. And this all has to be in a particular county, so this can't be statewide. And what was interesting to me is I remember as this process was going, as the bill was moving through AB 25, what is it? I forget the number. When the Racial Justice Act was moving through the legislature, it started out with the bottom part. So you just had to show these disparities. And the Judicial Council came back, as I remember it, and said, no, that can't be enough, because then it would just be, what if more people of one color commit a particular kind of crime, and then you would automatically give all those people relief? That can't be it. And we said, well, okay, so the authors said, what would satisfy the Judicial Council? And they said, well, there has to be some, similarly situated kind of thing. We have to be comparing apples with apples. And I think the authors thought that was totally reasonable. That's how social scientists analyze racial disparities when they do it empirically. But as we'll see in a bit, it has morphed into something that is that some courts have construed as a very high test that is basically impossible to meet. So here's an example of A3 when it did work. And this is Evan Kuluk's case. Evan will be talking later. This is in Contra Costa, the Wyndham case, and it was about disparate charging of gang murder special circumstances against Black defendants. And so what Evan did is he found two groups that were similarly situated and compared them. And so he was able to do that because under the penal code, a gang enhancement and a gang special circumstance are basically identical. There really isn't any difference between the two. And so he compared those two groups and found that Black people were being charged more often with a more serious gang special circumstance, which brought a life without parole sentence, than people who were getting the gang enhancement, which is basically the exact same conduct. So he was able to show that the odds of a defendant getting the special circumstance, 190.2, were much higher than the odds of a non-Black defendant getting that. And the trial court found that he had established a significant statistical disparity and that the DA had failed to prove race-neutral an alternative explanation. And in that case, the gang murder special circumstance was dismissed. So it can work very straightforwardly, which is not to diminish all the work that Evan did. He did a lot of work to prove this claim. But I think so far, sadly, this has been the exception rather than the rule. I want to talk a little bit about procedure. So the RJA sets up very clear procedural steps for bringing a claim. Under 745D, a defendant can move for relevant information. And to do that, he or she can request all evidence relevant to a potential violation of A in the possession or control of the state. And in order to get that evidence, the defendant needs to make a showing of good cause. Whoops. And so we have one case so far in the books, the Young case that I mentioned so far, that makes very clear that it's a very low standard. It's even lower than Pitch's standard. The defendant simply needs to make a plausible case based on specific facts that one of those pathways might have been violated. And I will say that since Young has been decided, the D motions are going a little more smoothly, and people are getting data, but it is still a work in progress. If you want to bring a claim in the trial court, you can file under 745C and argue that you have made a prima facie showing of a violation in order to get an evidentiary hearing. So the statute is very clear. If a defendant makes a prima facie showing of a violation, then the court shall hold a hearing. There is no discretion by the trial court once a prima facie showing has been made. And the prima facie showing is defined very generously in the statute itself. So it means a substantial likelihood that a violation of A has occurred, but a substantial likelihood is defined as more than a mere possibility, but less than a standard of more likely than not. So under the standard, more than a mere possibility, you would think that we would be having hearings right and left. Sadly, that is not the case, which I will talk a little bit about in a minute. There have been a couple of cases that take on this prima facie standard. And the first one was Finley, and it was very helpful. I think it set some very clear standards that will help trial courts figure out when to find a prima facie showing and give a defendant a hearing. So under Finley, the defendant has to fully and with particularity state facts that are the basis of the claim and include reasonably available documentary evidence. But once the defendant does that, the court then does not start weighing evidence, does not start making credibility determinations. The court really needs to take that evidence at face value. And I think it's very important to point out that Finley makes clear that the RJA standard is lower than the habeas standard. So in habeas corpus, we see the prima facie showing coming up a lot. But what it means there is that if the defendant presents facts that the court accepts as true, it has to prove the violation. Okay, that is not true in the RJA context. So in the RJA context, if the court accepts the defendant's facts as true that are pled, the question is, would those facts possibly make a violation? So it's a much lower standard. I think there's been a lot of confusion in the trial courts about that. I think Finley goes a long way to clarifying that issue. And then Finley also tells us that the court should accept the truth of not only the claims, but the expert declarations, if those are proffered, any statistics, unless those are conclusory, unsupported by the evidence that the defendant has presented, or demonstrably contradicted by court records. And then in the RJA, the prosecution is given the chance to show that any disparities that the defendant claims exist are actually explained by race-neutral reasons. So Finley says that needs to happen at the evidentiary hearing stage, not at the prima facie stage. So what we were seeing is prosecutors coming in at the prima facie stage saying, oh, there are lots of reasons, that these disparities exist, and the court didn't know what to do with that. And I think Finley makes it much clearer for everybody. What does not make it clear for pretty much anybody is the Mosby case, which came out recently. So in Mosby is a death penalty case that is pre-trial, and they presented an extraordinary amount of evidence. They presented 3 expert declarations. One was based on descriptive statistics about how many people were charged with death or sentenced to death based on population comparisons. Another was a regression analysis that took into account a whole variety of factors, including prior history, prior convictions, severity of the case, number of charges, all kinds of things. And just for good measure, they threw in some evidence, some statistical analysis that showed that Riverside was really beyond the pale in terms of charging youthful defendants with death. And so the trial court said, nope, that's not enough. The only way I can tell if people are similarly situated is if you describe to me people and their cases. So I want to see evidence that, Joe Smith did this. He's white. It's just like your client, but he got charged with something less than death. So counsel really did a heroic effort going through like that, literally 1,000 cases to try to pull out these narratives. And the court said, nope, that's not enough. So denied the evidentiary hearing. The court, they filed the writ and the Court of Appeal took it up and said, nope, the trial court has made a mistake. This definitely is enough to make a prima facie showing. But the problem with the case is that they didn't set a standard. They just said, this is enough. And we're not going to tell you if statistics alone are enough or if you have to have this narrative part. All we're going to say is in this case, it was enough. And so what we're seeing is that trial courts are still left with no guidance. And so some at least are saying, oh, well, then you have to have all the statistical analysis and all these factual narratives in order to get a hearing. That happened in one of my cases. When in fact, that's not what the Court of Appeal said. They just kind of said, in this case, it's enough. So it really does a disservice, I think, to the trial courts who need some guidance on this. And there's also a problem with the sentencing part of it. So they were challenging the death sentence, and they wanted to bring an A4 claim based on race of victim. And the Court of Appeal, in just like a throwaway footnote, said, no, you can't do that because he hasn't been sentenced. And while that has some logical sense, because you have to be sentenced in order to challenge your sentence, in fact, it makes no actual sense because as soon as you're sentenced, the trial court loses jurisdiction. So there is no way to bring an A4 claim. I guess it's possible that some court will end up construing A4 as giving the court jurisdiction after sentencing, but that doesn't make a lot of sense. So I think trial courts are really left without clear guidance there as well. But luckily in Mosby, there was also a concurrence, which is really excellent. I encourage everyone to read it. That justice said, look, the 745 puts the burden on the DA to show race-neutral reasons for the disparity. If that's true, then to win a claim, the defendant doesn't have to negate every possible race-neutral reason because that is the DA's burden. And if you don't have to do it at the merit stage, you certainly don't have to do it at the prima facie stage. And then the concurring justice also really got statistical evidence, understanding that not all statistical evidence is the same. The descriptive statistics aren't the same as regression analysis, and said statistical techniques such as regression analysis can show that racial disparities exist even when one controls for various relevant characteristics, meaning that racial disparities exist among defendants who are similarly situated. So the court got that regression analysis is a mathematical way to address similarly situated. If you can get through the prima facie stage, you get an evidentiary hearing. Under C1, you can introduce statistical evidence, aggregate data, and expert testimony. And also the court can appoint an independent expert. So to win at the hearing, you need to show by a preponderance of the evidence that there's been a violation. The court is required to make findings on the record. There's a recent case that deals with the merits decision that came out of San Diego, the Bonds case. In Bonds, Mr. Bonds was stopped after a traffic stop. A gun was found in his car and he was charged. At the evidentiary hearing, his lawyer put on 3 expert witnesses. One talked about the empirical evidence on on stops, police stops, and how they were racially disparate, especially against Black people. Another was a police practices expert who talked about ways that the particular stop indicated a pretextual stop. And then a third was a sociologist who talked about implicit bias, and especially implicit bias in policing. And then the officer also testified and said, no, I didn't know he was Black. That's not why I stopped him. And so the trial court said, okay, A1 is denied. He didn't know Mr. Bonds was black, so he couldn't have discriminated against him. And the Court of Appeals said that is not the standard. That is not the correct standard. That would be explicit bias. But the RJA also goes to implicit bias, so unintentional conduct. So they sent the case back to the Superior Court. Unfortunately, Mr. Bonds didn't win outright in the Court of Appeal. He has to go back to the Superior Court for a ruling under the correct legal standard. I want to talk just briefly about remedies, and I want to preface this by saying the RJA the legislature was very clear in the findings of the RJA that it was not meant as a punitive measure. It was not, the RJA is not designed to call out bad actors and to punish them as a result. It's really about remedying harm. And so I think that it's important to keep that goal in mind when remedies are being decided. So under 745E, remedies are required. The court shall impose a remedy if there's a violation. And the statute lists a number of possible remedies. At the trial court, there could be a mistrial, the jury panel could be discharged, or in the interest of justice, enhancements, specials could be dismissed. And then also for specific to the death penalty, if there's a violation, the client is no longer eligible for the death penalty at any point. And then there's this catch-all, and people have been using this creatively. We've seen, for example, jury instructions that have been used as remedies. So getting back to bugs, the question on appeal was the remedy. In that case, there was no question there was a violation. And after this special circumstances meeting, the DA decided not to seek death. And so the sole issue on appeal was whether that was a sufficient remedy or there needed to be something more. The defense argued, that was just the result of the special circumstances meeting. It wasn't a death appropriate case. And so the remedy has to be something additional, for example, dismissing the special circumstance. Unfortunately, the Court of Appeal did not agree to that and said that what the DA had done by not seeking death was sufficient. Thinking about remedy in terms of appeal, we have the Simmons case. So in the findings of the RJA, it says that a violation is a miscarriage of justice. And miscarriage of justice is a very specific term. It's in our Constitution and governs when you can get relief on appeal. So the argument there was that the RJA actually violates the Constitution because you can't statutorily declare that something is a miscarriage of justice. The court, the majority said no, the legislature does in fact have authority to designate something as a miscarriage of justice and has done so in the RJA context. And that forecloses a traditional case-specific harmless error. So when a case goes on appeal, usually the Court of Appeal will have to decide if there was error, if it had any harm, if it was prejudicial. And so in the RJA context, the answer is it doesn't matter. If there's an RJA violation, there is a remedy, period. The dissenting justice did not buy that at all. He thought that the legislature had usurped the judiciary's authority to define what's a miscarriage of justice, and therefore it was a violation of the Separation of Powers Clause. He actually urged the California Supreme Court to take it up on its own motion. In this case, it was unusual that both sides were arguing the same thing. So the Attorney General was arguing that it was a per se violation, reversal, that there was no harmless error standard to be applied. So nobody was going to petition for review because the parties weren't in agreement. The court ended up not accepting it. I doubt this is the last thing that we'll hear on that. I'm out of time, so I'm going to run through these really quickly. Other issues are about appeal, whether claims can be forfeited. The courts are all over the board. So forfeiture is about when the trial attorney doesn't raise the issue, can you still raise it on appeal? The courts are all over the board, and you can look at these later. So the last thing I wanted to talk about was retroactive claims. Folks probably know that they started in January 1st, and I really have nothing useful to say about them. It's going to be a long slog to figure out exactly how these claims are brought and resolved. So basically, you can file a motion or a petition for habeas corpus. The language is a little unclear about what that means exactly and what the standard is. But I want to wrap up by saying that although we're here to discuss the RJA specifically, I think it's important to remember that it is no panacea. So even if somehow magically tomorrow the RJA were perfectly implemented, we would still have racial bias and disparities in the criminal legal system. That there is no statute that can fix all of the mechanisms that by which racial bias and disparities enter the system. But I hope that we all look at the RJA as inspiration and as a way to think about disparities and bias that will encourage us to work together to find other ways to rid the criminal legal system of bias and disparities. Thanks.
It's so common to do all of this on Zoom and online that I realized I hadn't met my panelists in person yet. Good morning. I'm a member of the faculty at Santa Clara University School of Law. My name is Margaret Russell, and I'm going to be your moderator today. I am delighted to have a wonderful group of panelists. One of them lives a couple of hours away and was impacted by the storm. Maitreya Badami, who's actually an old friend of the Innocent Project and Santa Clara. So she's going to be joining us online, and we're very fortunate that she actually has Wi-Fi reception. But so instead of starting with Professor Badami, I think I'm going to reverse the order that it is on your sheet and introduce and then proceed with Professors Thompson, Malloy, and then finally Badami. There'll be time for questions and answers and conversations among the panelists, from me, from you. And I see these microphones at the side, so that'll be a really great opportunity if you want to make sure that your voice is very well projected. You can come up to the microphone at the end. Thank you for the welcome and the overview. The Racial Justice Act, I know, has drawn you practitioners because it is so vitally important to the work that you do. The name of this panel is Historical Narratives and the Racial Justice Act. And you may be wondering, this isn't history class. What is this about? But of course, you know how important it is, because just as narratives, factual narratives, are so important, the stories in your cases and the actual facts that drive your defense or prosecution of these cases, then so it is the case that it is very helpful to hear about the work of scholars and teachers whose expertise is delving deeply into historical narratives, connecting the past to the present, connecting so-called impact to intent, to the history that reveals to us discriminatory intent. There is a famous quote actually attributed to the author William Faulkner that you may have heard, which is the past is not gone. The past is not dead. In fact, it's not even past. And that has inspired some of my work and the work of someone who has also inspired me, and that's Toni Morrison, whose beautiful writing, I think, about the past informs our understanding of where we are today as a nation. And so against that backdrop of history, you're going to hear about some very important areas. I'm going to start with Professor Mikah Thompson and introduce her. She has really a wonderful bio and set of credentials that you can find on the website of her University of Missouri, Kansas City. But I do want to tell you a little bit about her. She is, I believe, presently the Associate Dean of Diversity, Equity, and Inclusion, speaking of historical narratives that some aim to rebut. She is a law professor and legal scholar who also teaches the following courses: civil procedure evidence, race in the law, and employment law. And she was a full-time faculty member there, I think, beginning in 2005. Of particular interest to us is that her research centers on the intersection of evidentiary law and race. Recently, she has written on juror bias, describing the impact racial stereotypes have on the way in which jurors assess trial evidence. She's also published articles on the cultural meanings of silence, advocating for a revocation of the tacit admission rule. And she is going to talk to you about the use of hip-hop lyrics and rap lyrics in trials as evidence. Professor Thompson.
Well, good morning. Is it morning? I'm on Kansas City time, so I'm all messed up. Yeah, I think it is morning still. So I'm excited to talk to you about the use of rap lyrics. I've got 10 minutes and, law professors, very long-winded people. So I'm going to do my best to get done in 10 or to get close at least. So what I'm going to do, let's see, this is my clicker here. Yeah, this is the plan. So I'm going to talk about the Black oral tradition and where hip hop fits within that Black oral tradition. I'll talk about the ways in which rap lyrics are used as trial evidence and some of the legal protections that are out there. So I'll be, spending time, especially during our discussion on the RJA and how it can be used to address the misuse of hip hop lyrics or the latest attack, I would say, on the Black oral tradition. And I also want to give a shout out to my co-author, Sierra Rahim, who just took the bar exam. She was my former student. She finished it up on Wednesday and is probably on the beach. She's probably not watching, but just in case, I just want to give her a shout out. So what is the Black oral tradition? You can find all kinds of definitions if you try to look this up. But there are some things that are highlighted in this definition that I found that I really like. First, the idea of kind of passing down stories and histories from generation to generation. It's not done, hasn't been done traditionally in writing. Also, importantly, the Black oral tradition, as we understand it, has its origins in West Africa. So it predates the period of slavery. So the Black oral tradition has certain conventions or customs, and some of those are here on the screen. So call and response, right? We see that in Black music. We see it in comedy. We see it in church, turn to your neighbor, you might know what I'm talking about. We see the dozens. So we see the kind of insults, right? Even if they hurt a little bit, maybe they're done. It's a joke. Maybe it's a part of lyrics, but the playing the dozens. Boasting or signifying. So this is talking about what I have and what I do, how much money I have, right? How successful I am romantically. So we see that dating back a very, very long time in our history. And oftentimes those stories are stories of adversity, of difficulty, but also stories of hope. And we see that showing up in many different places. So rap music is a part of that tradition. And the reason that I say it this way is because when we consider the use of rap lyrics as trial evidence, what we're really talking about is, again, what I've said, an attack on the Black oral tradition in its probably most well-known form, I say, because people understand hip-hop more than the other parts of the Black oral tradition. And so there are conventions that, were on the first screen that also show up in hip-hop. And then there are some others that are there. So, and these are important because when we see the evidence coming in, we see these conventions or jurors being exposed to these conventions or customs. The first one is the alter ego. So the alter ego, who's this guy on the screen, right? He's got many names. So what is his name? Yeah, see, they're all different, right? So Biggie, Notorious B.I.G., Biggie Smalls, Frank White. Yeah, I mean, Christopher Wallace, that's his government name, right? But it's the alter ego that is a convention of the genre. The use of the N-word is a convention of the genre. It is so prevalent in is so common that I would call it a custom. Boasting about, money, crime or violence, maybe women, things that are definitely not true. You can go back and look at the history of hip hop and look at what rappers were saying at any given time about all the money they had when they were obviously broke. They were making a demo, right? But the demo had all of this stuff in it about the amazing things that they had going on. And then the use of the I, which I think is one of the most compelling parts of this and the most problematic parts, I'd say. So I've got a quote from, there we go. And I want to read it. I know it's on the screen, but this is what I do. I just read quotes on the screen sometimes. Like many forms of subjective poetry, after all, gangster rap insists on the pretense of the I of its lyrics is the actual poet. And when this pretense is combined with transgressive content, it becomes even more difficult for an audience to distinguish the markers of poetic discourse and to separate an author's autobiographical reality from the fiction of the work. So therein lies the problem with the admissibility of rap lyrics, right? Because when they come in and when jurors are taking them in, they think they're true, right? When really the use of the I is just a convention of the genre, right? And when we look at other genres, we don't see the same thing. We don't see the same expectation that everything that the performer is saying is true. Nobody really thought Bob Marley shot the sheriff, or that Johnny Cash killed a man in Reno just to watch him die, or something like that, right? So there's something different about the way that these lyrics are treated. So how is rap used at trial? How are rap lyrics used? In a variety of ways. I kind of try to boil it down to about 4 that are the most common uses. So direct evidence of a threat, right? There's a whole lot of cases about this. You've got music, you have called someone out, you've said what you're going to do to them, right? If that is a threat, then of course can be prosecuted for that. I'm really interested in some of the other ones, though, right? For example, what I would call 404B evidence. I teach the federal rules of evidence, so I think about it in terms of those numbers. But to prove motive, knowledge, intent, plan, or identity to a prior act or an other act is what it is called there. Also, as evidence of the commission of the crime, what I mean by there is an admission or a confession. So lyrics written after a crime has happened that somehow link the performer to it. And then to prove gang affiliation for sentencing enhancement purposes. So the lyrics are used to prove, hey, this person's in a gang. And we know that to be true because they said it in their song. So at the sentencing phase, there should be an enhancement. So there are many cases out there. And when I want to say this, when we're talking about the use of rap lyrics, it's not just these very high profile cases like, Young Thug, that's a really high profile one, but just regular folks who keep a notebook, with some lyrics in it that get confiscated, or an amateur rap artist who decides to create some videos and upload them to YouTube. Those are discovered at some point and then they are used, right? And if you look back to work that came out in the 1990s in some prosecutors' manuals, they were encouraged to look for rap lyrics, that this will help you paint a picture of who the defendant really is. So just a couple of cases I want to highlight real quick where we see this use. And of course, this is Jeffrey Williams, also known as Young Thug. So I use his picture. But again, happens to regular folks, not just people who are famous and who are making money from the art form. So U.S. versus Wiley is a case where the defendant uploaded some videos to YouTube, right? And he was doing various things, sitting on fancy cars, holding lots of cash, rapping about his activity in the world of drug distribution. That evidence was offered against him to prove his knowledge of the drug trade. So that's a 404B purpose for that evidence. Green versus Commonwealth is a case where a defendant was charged with killing his wife. It was undisputed that he had killed his wife. This is a case out of Kentucky. His defense was extreme emotional disturbance at the time. So he wasn't immediately arrested. He had a bit of time pass before he was arrested. He recorded a song during that time and talked about what happened. And so that evidence was used against him. He didn't give too much detail about what went on, but he did admit that he killed his wife and that he was experiencing extreme emotional disturbance at the time. He also said he was sitting in a cell staring at 4 walls, which wasn't true because he hadn't been arrested yet. But all of that evidence came in against him. And then finally, the Young Thug example, the one that's happening right now, where recently the trial judge has admitted 17 sets of rap lyrics against Jeffrey Lamar Williams. The charges there are RICO, so racketeering charges, alleging that YSL is a criminal enterprise or gang. That's also the name of his record label. And in that case, it's really interesting. So the 17 sets of lyrics have been, they've been conditionally admitted. There's some foundation that the court wants the prosecution to lay. But what has already been established is that he didn't write them all, right? So lyrics he did not write, but only performed, have been admitted against him. So what does it mean to admit rap lyrics? What impact does it have on the jury? So we started at baseline level. Jurors have racial bias. So let's start there. It is, right? I mean, we all have implicit biases. Jurors are just like us. So there's going to be some base level. But of course, we can, commit to not use that bias to make decisions, and that's fine. But when we get the rap lyrics admitted at trial, there are many things that can happen. First, that the social science tells us that there are negative perceptions of the genre itself. So it's just simply describing the lyrics as rap lyrics results in more negative judgments by study participants. Negative perceptions of the person who's performed, the triggering of those implicit biases and stereotypes. The social science research tells us that happens. But then there's like really explicit stuff that happens too. So very explicit references to race, explicit references to racial stereotypes, because that's in the music, right? That is in the lyrics. It's a convention of the genre. And there is, of course, exposure to the N-word. You can look up cases. You can go on to Westlaw or Lexis and take a look at a lot of cases where judges are explaining, well, the ER ending is not the same as the A ending. And so, one is, highly inflammatory. The other one is a sign of camaraderie. So it depends on which one it is. When really the question about exposure to the N-word is whether it inflames an individual juror, right? And whether it infuses some sort of racial bias into the proceedings. There are also some cases that tell us that once the lyrics come in, it allows for the gratuitous use of the word by prosecutors. So there's a non-rap case where it's called Guerrero, where the defendant had used the N-word, and where thereafter the prosecutor repeated it 23 times in many different places, asking questions of various witnesses or in closing arguments. In another case called Green, the defendant, this is also a non-rap case, the defendant had written a letter while awaiting trial where he described himself as a trigger-happy N-word. It ended with an A. He put quotation marks around it because it was actually a quote from a rap song. But the prosecution got their hands on the letter. And during sentencing, in terms of trying to prove future dangerousness, the prosecutor was able to use those words and to use the N-word, arguing to the jury. This is what he's already called himself. The prosecutor puts an ER on it instead of an A. And there was nothing wrong with it, according to the courts that, took a look at this, according to the appellate courts, because it was the defendant's own words, not the words of someone else. So what are the solutions here, right? So the Constitution doesn't provide a lot of help. First, because the First Amendment is not going to be any sort of bar to trial evidence like this coming in. The First Amendment might help in some of those direct threat cases, but not generally speaking when it comes to rap lyrics. I'm going to talk more probably about the 14th Amendment when we get to Q&A and how it is also similarly unhelpful. Two things I want to note before I sit down. First, the California Evidence Code 352.2, which imposes this very interesting balancing test, right? That is not like the run-of-the-mill kind of, unfair prejudice balancing test. And it really talks about creative expression and the fact that it might be fictional, right? That's something that the court should take into account. And when the court is considering undue prejudice, it should also be thinking about the possibility that racial bias might be infused, right? Might result in the jurors' access to this stuff. And I think that is wonderful. The second part of it allows for testimony about social science research, explaining the impact that this kind of thing would have on the jurors. But when you look at the cases using the rule, what we've seen is that judges have said, well, it's harmless error, if it happens. And also, in cases where jurors have been instructed not to use their racial biases, we feel pretty good that they haven't done so. So it's not really doing the job. The RJA is better. because I think it centers the issue of race much better than other things that I've seen. The only thing that gives me pause about it is this sentence. This paragraph does not apply if the person speaking is relating language used by another that is relevant to the case. And so when I think about the prosecutor, trigger happy N-word, is there a loophole in there? I mean, could the court say, well, it's okay to say it because the prosecutor is simply repeating what the defendant said about himself, right? So I'm going to stop there, but I'm looking forward to chatting more about how the RJA might help in this area. So thank you.
Dr. Kerry Malloy has a doctorate of philosophy in Holocaust and genocide studies and a master of jurisprudence in Indian law. Let me tell you a little bit about him. Dr. Malloy is enrolled Yurok of Karuk descent. He's an interdisciplinary scholar of Indigenous and genocide studies whose research explores the potential obstacles and application of transitional justice in societies that have experienced genocide or mass atrocity events, when the structures that facilitated those acts have not transformed. From the perspective of critical Indigenous studies, the extent to which transitional justice is possible without the regime change of the settler, colonial, systemic educational and governmental structures is in question. This poses a dilemma, which he will talk about. And San Jose State, right, is your university, and you're going to talk about a context for understanding legal dynamics of California Indians and tribes. Thank you.
Ayakui, good morning. Okay, my 8 o'clock freshman can do better than this. Good morning. Okay, the coffee's hit. I'm going to talk about a complicated topic, but first I need to put you in a different space. And I want you to think what you know, or what you think you know, about Indians, about Native Americans, about Indigenous people, and where that actually comes from. Let's traumatize you, just for a moment. Think about your high school experience. When did you stop learning about Native people? You probably, if you were in California, you did the mission project based on our ages. Roughly around 1849, we disappear. We no longer exist. We reappear roughly around the 1960s with the Civil Rights Movement and the Red Power Movement. And then we're forgotten again until gaming. What do you really know? How much of that is informed by Hollywood, by fiction, by the amalgamation of a vast cultural experience that is different, that is influenced by geographies around this country, by a multitude of languages, belief systems, and worldviews? I am Yurok, which means I am downriver on the Klamath. I am Karuk, which means I am upriver on the Klamath. I come from Salmon people. I come from World Renewal people. We were given the task by our Creator to maintain this world in balance for all living people and things. I was born on the Pine Ridge Indian Reservation in South Dakota, where the average lifespan for an American Indian male is 48 years. The average lifespan for an American Indian woman is 49. The average income on that reservation in 2023 was $5,623. I grew up on the Quinault Reservation in Washington State, a fishing village that is being impacted by climate change. Two vastly different cultures, one from the plains, one from the Pacific Northwest. But I am not of those people. I returned home to California to live among my own people in the southern portion of the Pacific Northwest, which is vastly different from the cultures of what we call Northern California in the Bay Area or Southern California. We speak different languages. We have different experiences with how the federal and state governments treated us. That is my story. That is the story of my sisters. That is the story of many Native people around this country. But when you talk to us, when you see us, we are that fictional character that you interact with. We are a resource. If we look at the history of California from statehood on, the practice of this state has generally always been to erase and replace the native population. First, by the taking of the land, by the extraction of resources, by passing the Act for the Governance and Protection of Indians, which made it completely legal to place us in a slave state. The federal government removed our children to boarding schools in Riverside, California, the Sherman Institute, where my great-grandmother and her brothers and sisters went, to Bishop in Nevada, on the California-Nevada border, and to Chemawa in Oregon. Our experience with the legal system is one of absolute oppression. We are not just a race. We are a political status. We are the only minority group, I'm going to use bunny ears here, that has a legal definition in the Federal Code of Regulations. We are legally defined. The legal term is Indian. But we use Native American, we use Indigenous, we use American Indian, we use all of these components. And when we come into contact with the legal system, every single one of us knows this. It's been beaten into us from day one. We do not get the talk that our African American brothers get about what to do when the police comes. We get the talk of, do not identify. If you can pass like myself, who visually presents as white, tell them you're white. Tell them anything but you're native. Don't tell them that you're out on that country road driving to ceremony at 2 o'clock in the morning, because our ceremonies for my people and other people in the state happen at night. And when you get pulled over and asked why you're out there, tell them you're on your way home from a party, because that would give them a clue. We don't need to worry about a juror finding out our racial identity because it's talked about. All they have to do is find out where we were arrested. Were you arrested on the reservation? Why were you there? Who else goes on reservations but Indians? When you look at the demographic data, we don't show up. Think about your counties that you're in and the numbers you are working with. What is the percentage of native population that you actually see? Where are we hidden? Are we checking the box marked other because we know better? That is all part of it. But our culture comes into this too. What does it mean when you know culturally there are things you cannot talk about? And you're sitting there with your defense attorney who's trying to represent you to the best of their ability, but by cultural standards, you cannot tell them certain things. Or, depending on your positionality in your tribal group, you may be actually talking to the wrong type of defense attorney. Are you a woman who, because of your position, doesn't engage with men outside of the community? I had the opportunity to work for federally recognized tribes for 15 years. I worked a lot of Indian child welfare cases as the tribal rep in the room. And I come from an area of Humboldt and Del Norte counties, which has the 3 largest tribes in California, Hoopa, Yurok, and Kuluk. You would think that in the counties that had such a large Native population, the courts would know what to do. But it was not uncommon to be working with young men and women who were facing the juvenile justice system, or a mother and a father trying to keep their child in their home, who would hear from a judge or a prosecuting attorney about how they were sitting, head down, not looking at people, not making direct eye contact, because that's not what we do, because that's an insult. That's a threat. Those are the components that we have to take into consideration. We have to understand that the legal context in which we have been placed disregards the cultural reality of who we are and how we have to transform ourselves to interact with another world outside. The Bay Area represents a very interesting component of the Native story of this country, in that it is one of the largest relocation centers. During the 1960s, the Bureau of Indian Affairs relocated Native people from across this country to urban centers: Chicago, Oakland, San Francisco, San Jose, Los Angeles, Seattle, to learn to become hairdressers, travel agents, construction workers, mechanics. So you're not just working with a population that is native to the state. You're working with a population that is from across this country, who may not understand the complexities of the California story. When I was offered the position at San Jose State University, I had to go tell my mother, because, you know, if you don't tell your mother, you're going to be in trouble. And I went and saw her, and I'm sitting there with her and my dad, and I said, well, I have a job offer. And she goes, okay, where? And I said, well, it's not here. Well, that was a huge disappointment. I had failed her because I was moving away. And I said, I'm going to be teaching at San Jose State University. And there was dead silence. And she goes, why would you choose to go to some place where your own family was relocated? Because her brother had been taken and assigned by the Bureau to learn to be a garage mechanic in San Jose, California, 2 blocks away from the university I now teach at, a spot that I pass every single day on my way to campus. What does it mean when we take our Native people and place them and incarcerate them in facilities that their own families can't get to? And they know this, and they understand that there's a burden that they have to bear. And they don't know how to express that this is also the continuation of the policy of removal. So as you're working to implement the RJA, it's not just about what is written in the law. It's also about what we are experiencing as individuals and people, and what we know our families are going to go through, and how all of that culminates into how we decide we are going to either defend ourselves or be quiet. Right. Do you understand the cultural context in which you are working with your clients? I have a tendency to shut down. Not to be rude, but it's, my brain doesn't always remind myself I'm in a white world. And people look at me a lot of times going, well, he's white. Look at his name, Kerry Malloy. He's got to be some Irish kid. Well, I'm partially Irish. I like that part. That's a good part too. So they don't always know how to interact. And so when I do shut down, it's usually because something has just been said that I'm like, I don't really know how to tell you you are absolutely wrong. I was called the other day into the office of one of the department chairs in my building, not in my department. And she says, I really need to talk to you. I'm like, okay. Why? And she's like, I've got a dilemma. All right. Dilemma, it's a university. When isn't there a dilemma? Okay. And she says, you know, my sister works up in Oregon, and she sent me this T-shirt. And it has a native design on it. And I feel like it's cultural appropriation to have to wear that. Would you like it? After thinking of many things to say, I stopped myself, which is highly unusual. And I simply said, you know, I don't wear T-shirts. But we have the clothing closet on campus. Maybe it could go there. That tells me a lot about what a colleague thinks of me. So when you're talking to your clients, when you're listening to how they're being talked about, think of that component of, are you turning them into an object? Are you understanding who they are? Are you understanding their story? Because that story is what makes the RGA possible to achieve. Thank you.
So, as I mentioned, Maitreya Badami was headed out yesterday, and there was a storm, and I think trees were broken and lines were downed, and so here she is, I'm very happy to say, by Wi-Fi. And let me tell you a little bit about her. Actually, before I do that, I'm going to put a pin in the fact that this is Ohlone and Muwekma Ohlone land, and tell a little story during the Q&A about the efforts of transitional justice, but mostly the history of this campus, which has one of the California missions on it. If you're from California, the mission is what you see or saw coming right up the front drive. But back to Professor Badami, so good to see you. Professor Badami is coming to us from Chico State, where she joined the Political Science and Criminal Justice Department in fall 2017 after a 23-year career in the practice of criminal law at the trial, appellate, and post-conviction levels. From 2010 to 2017, she taught and practiced full-time here with the Northern California Innocence Project, a clinical educational program that you've already heard about, I think. Prior to joining Santa Clara Law faculty, she practiced in the Bay Area, serving as a deputy public defender in Contra Costa County, then as a member of the indigent defense panels for the San Francisco Superior Court. The first district appellate project, in addition to the indigent defense panels for the San Francisco Superior Court and the United States Court of Appeals for the Ninth Circuit. She's done research and extensive policy advocacy in relation to the role of eyewitness misidentification and wrongful convictions. And she's going to talk about the RJA, specifically beginning with shaken baby syndrome cases. Welcome back, Professor Badami. Thank you.
To see you, and really grateful to be able to be here on Zoom. I am sorry that I was not able to make it down there. Indeed, I've still been fielding calls from PG&E and an electrician and a tree guy, even while I'm listening to my co-panelists. I'm at someone else's house because my power's out. Anyway, I'm really grateful to be among you. I have an article coming out in the Stanford Journal of Civil Rights and Civil Liberties entitled Preventing and Correcting Wrongful Convictions for Abuse of Head Trauma Using the California Racial Justice Act. I thought it was going to be in the February edition, but I actually heard yesterday it's in the next volume, which is in May. And so I will have a link available as soon as I have one. I also, yesterday was a hard day. I learned that the article wasn't out and the tree knocked out my power. Anyway, my piece is essentially a thought experiment because as the RJA was being amended to make it retroactive, I was really thinking about its potential application in wrongful conviction and habeas corpus litigation that we did at Northern, and they are continuing to do at the Northern California Innocence Project and the other innocence projects in California. And also people working on habeas corpus petitions that are outside innocence projects. So having been at NCIP for almost 8 years, I was aware of data that shows pronounced racial differences in exoneration rates. We can't, obviously adequately estimate the racial impacts of wrongful convictions. We don't know because we don't really know how many people of the hundreds of thousands of convictions annually are wrongful convictions. And we can only make educated guesses. And some have estimated as high as 5% of convictions, some as low as 3%. I don't really think anyone who really studies the US criminal justice system believes it's lower than 3%. Even still, it's a lot of people serving jail and prison sentences for crimes they didn't commit. And while the RJA makes no distinction for factual innocence, when you can see that even the innocent defendant of color appears to be more likely to be convicted than a white defendant, it makes you look for any additional tool to add to the arsenal. So I was most interested in considering a kind of case where the impact of implicit racial bias might be the differential between a criminal charge being filed in the first place. So a situation where the question of whether even to engage in a criminal investigation was warranted. So this, of course, made me think about shaken baby syndrome, which is currently referred to generally as abusive head trauma. In this sort of case, which over the past couple of decades, it's emerged as a particularly problematic criminal charge. I mean, not getting into any sort of detail here in the brief time I have, suffice it to say, the initial finding that a particular set of physical symptoms suffered by an infant or small child were the result of violent shaking has come under tremendous scrutiny and appears to lack any actual scientific basis. So this uncovering of this has not before thousands of parents and caregivers were convicted of child abuse and even homicide on the basis of that set of findings. Right? So my piece is my sort of first stab at bringing together some of the data around the racial differential in exonerations. So in short, the National Registry of Exonerations put out a study in 2022 that while Black people are 13.6% of the American population, they represent 53% of the 3,200 exonerations listed in the National Registry. And judging from exoneration cases only, innocent Black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. I also looked at studies of medical decision-making and race, seeking information about the implicit bias that might lead an emergency room doctor or social worker to refer one child for a child abuse investigation, but not another, both children presenting with similar medical symptoms. And having just heard from my co-panelist, Dr. Malloy, I would note that a Washington State study that I cite in that paper showed that Native American caregivers were the single most likely group to be referred for a child abuse investigation in a statewide study of emergency room referrals. So I looked at a 2021 controlled study by Drs. Judy Melinek and Itiel Dror and colleagues, which seems to suggest that forensic pathologists' initial determinations of cause of death in an infant death were in part influenced by awareness of the race of the caregiver. Specifically, medical examiners were more likely to find homicide probable when the caregiver was identified as Black than when they were identified as white. So these sort of different areas of study into racial impact and disparate racial outcomes, together make me believe that a person is far more likely to face a criminal investigation and potentially criminal charges in a situation involving symptoms that have been, collectively called abusive head trauma, if they are a caregiver or parent of color. And I believe that the Racial Justice Act is going to become a critical tool in addressing this kind of insidious disparity. There isn't any actual data on exactly the intersection of the issues that I'm talking about because it's every single case especially in the wrongful conviction world is essentially seen as a very unique and standalone case, and it isn't seen in its systemic role in the place that it is systemically. But I believe that RJA is really going to start to make a difference in that analysis. Like every single wrongful conviction case is currently, I think I might be offline. Okay. Every wrongful conviction case is litigated, of course, as the individual case is. And I think the system tends to look at it as an anomaly. Whenever there's eventually a judicial finding that someone was wrongfully convicted, that they were factually innocent, they're seen as a standalone issue, even though we are well aware of the most common contributing causes of wrongful conviction. But I think RJA is going to give us an opportunity to now include implicit racial bias as one of the most common contributing factors to the wrongful conviction of innocent people. So hopefully it will help us to reverse that particular trend. That's all I have today.
What we're thinking would be good is to start off with maybe a question or two that I have, or a question for each of the panelists, maybe going in reverse order and starting with Maitreya, and then open the questions up for you or whatever conversation you have with each other or reactions to each other's presentations. But first, I do want to thank all of you because this is such a it's an eclectic and yet pretty, in my mind, unified use of discussing really historical subordination and the connection that we can make and should make when we're talking about cases under the Racial Justice Act. So I wanted to start with Maitreya and ask if you could just maybe mention some types of post-conviction cases. And you talked about shaken baby syndrome, but mention some types of cases in which you think the Racial Justice Act will be a particularly helpful new tool.
So I think where it's really going to be really useful is in forensic-based wrongful conviction cases. Janice Puricall and others put out a study of implicit bias in criminal forensics a couple of years ago that really, she just really lays out thoroughly the role that implicit bias seems to play in the sort of judgment call by forensic scientists, forensics examiners in a variety of different, criminal investigations. Obviously, the medical examiner is one area, and that doesn't just apply to a shaken baby allegation. There are wrongful convictions of people for homicide that turn out ultimately to have been a suicide by another adult or an organic medical condition that resulted in death. So where the turning question and whether something is a crime or not turns on a forensic, scientific investigation and evaluation of evidence, could even include arson. Any place where that judgment call is really relevant to, is this a crime or not in the first place? I believe that implicit bias is always playing a role, and the more studies that people are doing of implicit bias in forensics, the more evidence we're going to have in support of the fact that the whole entire no crime category of innocence cases is probably deeply infected by implicit racial bias.
Right. Thank you. I do have a question for Kerry. And before I said, let me just put a pin on it to talk about the history of this campus as kind of an example of historical amnesia for people like me who did not grow up in the area. I grew up on the East Coast. I didn't have whatever this horrific fourth grade California mission project seems to have been, but since my kids went to groovy schools in Berkeley and Oakland, fortunately they didn't have it. That doesn't mean that they grew up learning very much more from their schools, but a couple of years ago, the President Ng of the university appointed a Loney history working group. And so there were, a number of us who were digging into the history of the university. I knew nothing. I learned things that made me never looked at walking across its campus the same way because I've been here for 30 years, but I did not realize that it is a burial ground for about 7,000 people, many of whom have documented baptismal records, death records, marriage records that are available through the library. So that is a very eye-opening thing. And I just mentioned that as another example of the invisibility, I think, of prejudice against Native Americans and almost this sense of amnesia of, oh, well, you know, there's this movie out now, you know, Killers of the Flower Moon, but, you know, all of this is in the past, right? It's not in the present. So my question, easy as it is, for Kerry Malloy is, how do you incorporate something as, I guess, literal and evidence-based as the Racial Justice Act and other legal tools to convey the depth and the sense and the historical memory that you are talking about? I think maybe more in a transitional justice context, but that should not just be in a transitional justice context.
That's a really easy question.
Oh, come on, Professor. Thank you.
You know, we were all kids at one point, and we were all angels, and even Lucifer was an angel. If you think about it, you grew up with brothers and sisters, cousins, friends, and at some point, something happened between you and that. It was not your fault. I knew that. There was a scuffle. There was something that happened, and an adult stepped in and decided to administer their form of justice, which was telling you to tell them you were sorry. And you said it, or you had it said to you. And some of you right now are thinking about that instant, and you know that person was not sorry. Or you're thinking about when you were told to say you were sorry, and you know darn well you weren't sorry. You do it again. That's how I incorporate it when I talk with my students is, you know, these can't be performative acts. They have to actually have meaning. And if we're going to implement it, then we need to do it and do it right. We need to have a intentional purpose of moving forward. We can't just gloss it over and say, okay, I brought these issues up and now it's settled. It's, yeah, you may get the conviction overturned. You may get the sentence reduced. But is that actually the justice we're looking for? How do we actually then do the actual repair of having someone regain their life or live it in a way that they can under whatever circumstances the decision of the court is? Because if you come to me and say, well, the best I can do is just get this reduced, that's not justice. That's the best we can do. And it makes me always go back to say, you know, well, you said you're sorry, but what else are we going to do here? How are we going to make this right? We can't give time back. Money doesn't do a whole lot, and I know that's an unpopular opinion. But how do we make it right? How do we actually apologize and accept the fact that we have given into our biases in making decisions? So I generally will take my students back to that time, and we all have that experience. And we always will remember it, whether it was a positive or negative. So I think we have to think beyond that performative act and actually make it meaningful.
Thank you. Mikah, I have some questions that I thought of before with your help, and then some in reaction to your presentation, your wonderful presentation. One is really if you could say more about the use of RJA, in which you had referred to, and the 14th Amendment, and their use.
Sure. Yeah. So the so I think the RJA is a reaction to the limitations that we've seen the Supreme Court put on the 14th Amendment, right? And it's a reaction to like McCleskey, you know, okay, got all this data showing this huge disparity. Well, it wasn't intentional. So there's no intent is required, right? So that's what makes it such a big deal that we're talking more about impact versus intent. And that I think will matter in individual cases that deal with rap lyrics. So there's a case called People versus Bryant. It's out of Contra Costa County. It was a 2022 case where there was a review of a conviction. Rap lyrics had been admitted, and there the court did order a new trial. And I wrote it out, or I didn't write it out, typed it, kind of a quote from the judge. It says, whether purposely or not, the prosecution's use of rap lyrics as evidence of Mr. Bryant's and Mr. Jackson's commission of the charged offense and gang membership premised their convictions on racially discriminatory evidence. It likely primed the jurors' implicit bias regarding negative character evaluations of African American men as rap artists and as being associated with crime. So this is how the RJA even differs from the evidentiary rule that I put up through 52.2, because there's this balancing test, right? So probative value versus unfair prejudice, however you define it, right? It's defined in that rule in a way that's harder to satisfy, I think, than how that balancing test normally works. But there you're considering how probative it is. So the court could be like, well, okay, I know it's got all this bad stuff in it and it's going to trigger a racial bias, but it's really important to the case, right? So we really need it. Whereas with the RJA, I mean, the question is just, was there racially discriminatory language used? Were stereotypes triggered? If the answer to that is yes, then it seems like that's it, right? That is a win. So I think that's why it is so important.
It's great. Thank you. And so I'd like to ask if there's some questions from you before I go on and ask more questions. Ask them of each of them. Anybody do? I know you're not shy, so I'll say no, don't be shy. Do you want this microphone? Okay, please. And if there's anyone else, you can line up or I'll pass this to you.
Professor Malloy, I was really struck by what you just said. I had a case involving Native American, and we had actually a national supporting us who's recognized by the federal government. And we ran the RJA, and at the end of the day, the sentence we were asking for, which was time served, was given. And the judge said, I'm not going to rule on your RJA, though. Your client's not going to appeal. He'll go home, but he's going to waive his rights, essentially, on his RJA. And so we achieved liberty, but I'm not sure what else we could get about afterwards. Now, this is a man who's part of my family. It's a man we try to take care of. And I'm wondering what else we could do outside of these legal constructs to really try and give reparations for that type of trauma. Because I can't even imagine, as a white person, trading my race for my liberty. That's essentially what the court made us do. Thank you.
Unfortunately, that's not uncommon. I wish I could say different, but I can't, as I've seen too much of it. There are some options depending on their status. If they are enrolled in a federally recognized tribe, their tribe may have a tribal court. And tribal courts have been moving in a different direction for some time. So I'll use the Yurok Tribal Court because that's what I'm most familiar with. We operate a wellness court in our tribe. They're in the process of going through and looking at cases that our members have been involved with in the state courts, and then they are using the tribal court system to do expungements, to consider certain decisions. And they're so Humboldt County and Delaware County Yurok Tribal Court are working through a process right now of ensuring reciprocity. The one area that they are having a little bit of a struggle with is dealing with fines, in which where the tribal court may say we are expunging the state record. That doesn't translate over into the financial system at this point. They may have fixed this. It was about a year ago when I ran into this issue. The fine still stays there, so it shows us something. So that's one option, is to move it into tribal court. that is a possibility depending on the relationship of the county and the tribes. If they are non-federally recognized, which is very predominantly the case in most of this part of California, you're stuck within the state system. But what you can do, and it's what you're doing, is this person's now become part of your family. And you can help them and show them that, you know, something has happened, and there's always an opportunity to tell the story. And the more that story is told, the more that people hear about it, the more that we are aware that this is happening, that people are being asked to trade their identity for a favorable decision, the less it's going to happen. Because very few people want their name attached to that type of story. So keep telling it.
Thank you.
Thank you. Question?
Good morning. Thank you very much. We have a very practical matter in the courts in trying to provide evidence of disparate treatment, and to an audience you've already described as less than motivated to call it for what it is. So if you have any thoughts or ideas about how one could design, collect, or reference narrative type evidence. If we don't have the statistical, the data science for showing particular disparity between groups, the evidence, the code allows us to be quite broad in our showing, and we really need some help to frame narrative type evidence, to design it, to collect it. We know that our clients are growing up in communities that are having generational experiences of those that we've heard from Professor Malloy, but in others right here in our county. So we have to be county specific, and we're struggling for ways to support the history of the bias and animus that we can then fold into our art form of narrative persuasive advocacy.
One way you can do that is I chair the Ethnic Studies Collaborative at San Jose State University. So we are a collection of all the ethnic studies departments: African American Studies, Asian American Studies, Chicana Studies, and Native American Studies together. We come together on a regular basis to talk about the state of ethnic studies, but also what it is that we can do. Connect with your universities. They have ethnic studies departments who are doing this work. They are out there already. You have researchers who are out there taking and collecting oral narratives, working in these communities who have the research. It is interesting from particularly the ethnic studies standpoint of the type of request we generally get. We don't get requests about our research and how it can help inform the legal system. Generally, our research is, it's African American History Month. Can you come and talk to my 8th graders? That's okay, but we have a world wealth of information that's sitting there ready to be used and accessed. And if you grab my card at the end, and I'll put you in contact with our Ethnic Studies Collaborative. That's one way to do it.
So, and I don't know.
Do you want to weigh in, Maitreya? Well, if you do, yes.
I wish I had. I mean, I've been paying close attention to the RJ implementation working group because there seem to be people connected into sort of every social science field where there are experts who are able to testify about this. But I've also watched the results where prosecutors and even judges are, attacking a study on the basis of how the study was formulated, and it's rather than taking in the important sort of social science narrative studies that the questioner was asking about. We have a really huge hill to get over with this. To even really implement the RJA at the level that it is aspirationally wanting to meet, we're going to have to break open the way the adversarial process has been working around expertise. And no, I do not have a good straightforward answer of like who to get the word from, but I know that my colleagues that are PhDs in criminal justice, many of them have a huge amount of work and history that they've and studies that they've done around racial disparities in sentencing, racial disparities in charging, and those are the people. Those are the people you need. But in terms of getting that information in front of a judge in a fashion that actually works and moves the judge, I wish I knew. I definitely, I'm listening as much as I'm talking on this.
Yeah, I agree. I mean, experts, come to mind. I hate to say training. I hate to say that. Sure, I mean, people just need to learn. We need judges to know this stuff, right? They need to understand these things. And so, I mean, there was a time when, folks didn't accept that we have implicit bias. I think maybe some people still don't accept it, but I think it's largely, we can mostly agree on that. And that took a lot of time, and it took training and education to get to that place. So I don't know. I feel like, when I think about, these narratives, these stories, this history that provides all this context, it'd be great for our judges to have the kind of training before they become judges or while they're judges that will inform what they do. Outside of that, I mean, I feel like you can do a lot with the judge outside the presence of the jury. I mean, if you're trying to, establish some things in a preliminary fashion, hoping that you'll be able to, admit some evidence as a result of it. Maybe there's more leeway. Maybe there's more room to use things that might not be admissible evidence otherwise to provide context to an individual judge.
Let me ask if there are any questions. Yes, please.
Is it okay if I just talk from here?
As long as we can hear you.
Perfect. So the past two questions were very, very good, but they're from a practicing perspective. As a student, what are some things that we could do to learn more or have some sort of impact? Because a lot of us aren't working yet, and I'm a 1L, so I can't choose any of my classes yet either. But what are some ways that students can, progress this?
I see some criminal law faculty colleagues here who might have some wisdom on this. David?
No, God.
Sorry to call it out like this.
I was told there would be no cold calling. I mean, I think this is part of your education. I think that all of the people here have, written articles that you can read. If you ever want to learn what influenced their own writing, you read all the footnotes that they cited, so there's a way of educating yourself about this. In terms of sort of being, the history of, the sort of criminal legal system intersecting with both, settler colonialism and, race, I'm happy to direct you to some of that stuff, offline.
Great.
How did I do, Professor Russell?
Well, I did hear Mikah say she had something to add. And do you have something to add to this or a question?
Oh, I just want to add one
Please.
thing. As a psychologist, I really think the need to have more social science incorporated into law review articles is huge. And it's something that, as both a lawyer and a psychologist, I've always looked for, and there's not enough of. So to the degree that you can, the same way it's important to bring in that historicity to legal analysis, I think it's important to bring in models of, competent models of human behavior, because everything we're talking about with respect to racial bias has a connection to the way in which the legal system views human behavior, which is fundamentally a 19th century view of human behavior. So they see behavior and they say, oh, that's a function of you as a person with a deficit, as opposed to your context and the stimuli that might make you behave a certain way, commit crimes, things like that. So that kind of nexus, to me, is something that I'm looking for from students and things like that.
Thanks. Yes.
I agree with all of that, definitely. The only thing I'll add is it's great that you want to go out on your own and do this, and you should learn. Your professor should also be teaching you this history. It is essential, whatever the topic. It could be evidence, it could be civil procedure, where we talk race and class and access to justice, and we see the ABA kind of moving us to add things right that were not there before, but it's the responsibility of the faculty to also give you that education, and for it to not just be this one elective class, but to be infused throughout your legal education, because it is. And the exciting thing though is that you will be the judge one day. And so, when we talk about, these judges don't understand, they don't get it. As we educate our future lawyers and judges on these topics, they will know and they'll have that context.
Yeah, and I it's great that the law review is focusing on this. I would also add that it actually in the standard 1L, 2L bar course classrooms, it's completely relevant to bring this up if it's not brought up already. And in the seminars that I've taught from gender and law, restorative justice, some of the papers have really taught me a lot about particular areas. So I would encourage you to look for independent research options and also seminar paper options in which you have the flexibility to explore a particular topic. I do want to add, I wanted to say that the interdisciplinary approach of all of our speakers really, I think, reinforces against what the Supreme Court happens to believe, the majority, that a contextual understanding is really what is important in understanding really historical subordination of all groups, to say the least. I know we just have a couple of minutes, but I at least wanted to get out this comment question to Mikah, something that I think about a lot, which is who can use rap lyrics with the N-word and who can't? And so this might be one step farther from talking about a particular trial with a particular defendant, but I'm aware a friend of mine handled an appeal, the case from Contra Costa County, in which a non-Black, I think he was white, he might have been Latino, defendant was a very big part of the prosecution was his utterance of the N-word with an AH in a bar. And whenever I tried to say to my friend, well, let's talk about the context that needs things like your professor just shut up. But the question, I think, is relevant because if we just follow the use of rap lyrics by Black defendants in order to establish, and let's say, an argument that the N-word or that other racial slurs, it could be, or ethnic slurs or religious slurs, means something different from what they would ordinarily mean on their face. What does that actually mean for evidence law and for concepts of racism? Does that make sense the way I asked it?
I think so.
Let me give you one example. If I'm ever on a jury in which someone actually, outside of quoting, says the N-word in its full word, I instinctively recoil. No.
Yeah, so I thought about this in a couple of different ways. So one is, will my conclusion be, and my paper's on it, will my conclusion be that, only Black and brown folks get, a benefit from this exclusion? If I think I'll be advocating that it not be used, but yeah, can only Black and brown folks benefit from it? What is the probative value of the N-word? That's another question, right? So of course there are old cases where, let's say there's an assault in a bar, and the person yells the N-word, and that is probative of kind of a motive, or maybe it turns it into a hate crime or something like that. So, okay, so perhaps I see the value of it there, maybe from the perspective of the prosecution, right? But in the scenarios that I'm talking about where it's used in lyrics, where it's kind of part and parcel of this whole image, but doesn't on its own really carry any positive value. I don't know why it is there, but I also know that there's a reluctance on the part of trial judges to redact it. They don't like the idea of removing it if it's, let's say, in a set of lyrics. So, and there are other stereotypes that are going to be harder to redact, right? So I think your question is, someone yells the word in the bar, they use the A. It's a
AH, and it's sort of like my brother.
Okay.
Okay, so that was the defense. That's the tone. It was like, hey, and word AH at the end. Like I was just saying, hey, my brother.
And I think the word is so inflammatory, and either it's ER or A or AH, depending on the individual juror, right? So what's the value of it in the case? Like, why is it probative? What is it?
It was a hate crime.
It was a hate crime.
Sorry.
Okay. Okay. So there would be this whole debate about what the intent was, right? So it's really probative because it's a hate crime charge, right? But what does it mean exactly? The A versus the ER. It's almost like you're asking the jury. The jury's going to have to decide, and they probably parade in experts to testify about. Well, no, actually, this is what it means when it's A, AH. This is what it means when it's ER. There's case law on that actually, where in the employment context. Okay. So where
this was a killing, so it was very high stakes.
So I think that would be the debate that the jury would have to kind of answer the question of what the intent was with the word, but it feels very probative in that situation. I think there are others where it's not as probative and where it's coming in anyway, inflating the jury. So, but the case in the employment context is someone sued Marlon Wayans, who was working for him, and said he called me the N-word at work all the time, and it was the A, right? And so there's a whole opinion about it. Well, actually, when he was using it in reference to another Black person, that was not the same as the ER version, and there's experts cited and whatnot. So I think that is what would happen in that.
So in employment, I have talked to employment discrimination. You can see me wincing when you're telling that story. No, don't do that. Anyway, this is great. Thank you. You have a break, short break, 10 minutes. Please feel free to talk to the panelists, and thank you to all of you.
Good morning, everyone. My name is Derek Morgan, and I'm here with Professor Laura Bazelon.
Hi, everybody.
Today, we're representing the University of San Francisco's Racial Justice Clinic, and thank you. And personally, as someone who's been working with the Racial Justice Act since its inception for many, many moons now, it feels, it's such an honor to be with you today in a room full of other people just as engaged with the Racial Justice Act, with the values that inclusion and honoring people's beings and respecting each other is something that our highest institutions can lift up. It's a beautiful thing and brings so much joy to my heart. And again, it's an honor just to be able to share with you some of what I've been able to learn in my few years with the Racial Justice Act. So I think a really good place to begin is, of course, by finding out how we got here. To this place where our laws, for the first time, finally allow us to challenge discrimination in our courtrooms. Of course, we can start with McCleskey, but even that sidesteps so much of our history, so much inhumanity that necessitated bringing the act to place in the first place. It skips over hundreds of years of abuse, forcing people into bondage, a practice that was so widespread, it was the engine for half of the world. That system of extraction, of indignity, of violence, that would rather see people like me as property to be had, rather than even acknowledge our shared humanity. Our institutions inherited racism. Slave patrols became militias, became police. Plantations became penal colonies, became prisons. Race has always been a silent character in the courtroom. For generations, it has colored who even comes before the court, who's surveilled, who's arrested, who is punished, whose entire neighborhoods are penalized and criminalized. All of that walks with us and our clients into the courtroom. But with the Racial Justice Act, we can finally give it voice. So McCleskey then feels like a perfectly fitting place to start. After all, that was the case that where the Supreme Court enshrined one of the most awful obstacles to acknowledging our personhood, where the Supreme Court decided that no matter how much evidence of racial bias you could show, that you could present that was impacting you and your life, you and your case, the court would do nothing about it. It would see it as a harmless error, inevitable in our system. But racism is never harmless, and it's not inevitable. For the 1Ls, I'll give a brief description of McCleskey, and for the rest of you, please forgive this review. But you'll remember McCleskey is the case where in 1987, the Supreme Court heard from a Georgia man that was challenging his death penalty conviction. In his defense, he would bring the court a comparison of over 2,000 cases that showed that above all else, more than any other factor, the color of his skin would determine whether the state would take his life. Still, our highest courts would do nothing about it. Again, seeing it as an inevitable part of our criminal justice system. It's so preposterous I can't even say it. The famed attorney and civil rights advocate, Michelle Alexander, will encapsulate the court's motivations that day, saying that the court intended to immunize the entire criminal legal system from challenges of racial bias, what the dissent famously called a fear of too much justice. But there's no such thing as too much justice. And even though that was the case in Georgia, and it carries all the connotations of the South, here in California, it's very doubtful that Mr. McCleskey would have fared any better. Here, a man is 9 times more likely to be sent to prison for the color of his skin. His family's black and not white. Our state is one of the top imprisoners in the country, making it one of the top imprisoners in the world. And racial disparities here are worse than they are in any of the states of the former Confederacy. Worse than in Texas, worse than in Mississippi, worse than in Florida. Twice as bad as the nation as a whole. Gang enhancements are used nearly exclusively to target Black and brown communities, to criminalize their relationships, their bonds, neighborhood bonds with each other. 3 strikes and other enhancements in sentencing schemes have had devastating effects on Black and brown families for generations. And also do nothing to address the root harms that we seek to condemn. The need to confront racism in our legal system is greater here than in most states. This was the impetus to introduce the RJA here. Here, 100 years after women finally gained the right to vote, but only if they were white. 75 years after the forced internment of an entire Japanese community. 50 years after the struggle for civil rights would try to bring us closer to union. 2 years after the state moratorium on the death penalty for its obviously racist application. With all this, advocates across California introduced the Racial Justice Act to challenge the notion that racism is inevitable in our state. Then there was 2020. That year made the call for racial justice undeniable. The twin pandemics that we suffered, the novel virus and our more familiar pandemic of racial violence, would play out before our eyes and lay bare the inequalities within all of our institutions. When we saw who was left most vulnerable to death. And when the Enlightenment came after the deaths of Ahmaud Arbery, Breonna Taylor, and George Floyd, that sparked, again, an enlightenment across our nation that we need to address racial justice. A demand that we honor our shared humanity. It was people power that brought the RJA. It did not come down from the halls of power in the legislature. It came from us in the streets. In fact, when it was a bill in the legislature, the RJA died and needed to be revived so many times. But it was the determination of the community behind it, the hundreds of volunteers, countless organizations based in the community, rooted in the community, and people from all walks of life that echoed the need for racial justice. Even when the fires cooled, it was the persistence of those same groups that allowed the RJA to become retroactive. Because as much as we need to heal our institutions, we must remember that our healing will leave no one behind. I want to just briefly shout out some of the organizations behind the coalition. It took a village to move mountains, but especially the Anti-Death Penalty Coalition, the CURB Coalition, Californians United for a Responsible Budget, CCWP, California Coalition of Women Prisoners, the League of Women Voters, Silicon Valley Debug, and of course the champions, the Ella Baker Center. And I also want to shout out our partners behind bars that supported us and urged us to push for the act, even when retroactivity was taken away in one of those early ugly amendments, because they knew how important it was, the work that we were doing, to enshrine civil rights in our courtroom, to do the most with this opportunity that was given to us by the people who took time out of their lives to protest in the streets, given to us by all of our ancestors and everything they survived to grant us this opportunity. That is how California gained the RJA. And I'm so happy that it's the law of the land. And I get to nerd out with it, with all of you in this space and beyond. So now that we have this power, what do we do with it? As the first generation with the RJA, we are on the cutting edge of what advocacy can do. I invite you now to carry with you the same spirit of the advocates who helped enact the RJA. Hold the righteousness to confront racism that would take away someone's life for something so arbitrary as the color of their skin or where they were born. Hold the bravery to call out the flaws in the system, in our system, and require that we address the harm that it causes. Trust that you are enough. I want to repeat that. Trust that you are enough. This is hard work. It's going to humble you. It's going to take more than you know you have. But you are more than you know. And you're not alone. Just look in this room. So do everything that you can as zealous advocates. We are limitless. Do everything you can until they make you stop. So what does zealous advocacy look like in this era where we're all empowered? It means, well, with that power, holding humility, recognizing that we all have blind spots, recognizing that there's an expertise with those about you that can help you with those blind spots. Especially the expertise of those in the system right now, especially the expertise of their families who are with their loved ones in the system, especially those who don't have your background. When we were working to pass the RJA, there were so many times when I had to humble myself and remember that I wasn't the expert in the room. Despite my many, many waking hours with the RJA, I was nowhere near as learned as my colleagues who had been incarcerated, who had seen the impact of racism, who had felt it in their bones. My role was to empower those with better perspective than me, allowing their wisdom to speak the truth to the matter. And as zealous advocates, I hope and I know that you'll do the same for your clients. In our work in the clinic, we're reminded of this principle every day and how it's baked into the RJA. Since the way to begin a retroactive claim is a habeas petition, the first thing we must do is listen to those who have been in the system, who can tell us about the flaws within it, who can teach us about the flaws within it. That's how our investigations begin at the clinic. Being a zealous advocate also means recognizing the virtue in those about you, especially the next generation of advocates and attorneys and experts. Today's generation is native to innovations that I saw in my, I think, relatively many years on Earth. I've seen those innovations change the world. I remember the world before the internet. Something that made the world that much smaller and bigger at the same time. Connected us all in ways that I can't imagine anyone could have dreamt of 100 years ago. They're native to not only this interconnected world, but also all of the liberties and freedoms that have been so hard fought by generations before. That's a gift and a virtue. They're much more fluent and sensitive to how our world normally overlaps than us that came a little bit before and have seen a thing or two. More and more social barriers are coming down. The social barriers that divide us seem small and smaller in the rear view. For instance, I can see in my family, in my cousins, in my nieces and nephews, that it's natural to have parents with different races. That it's natural to have family that is undocumented. That it's natural to be non-binary. The next generation is going to be so much more fluent in how all of our cultures overlap, and that is a virtue. I imagine that they know that identity is not a mold that we fit into, but it's these overlapping layers that wrap around our essence, around our form, and help others recognize our experience. But it's not all of it. This next generation carries the expertise to be a voice with their clients. That is the spirit of the RJA, to bring more voices, to tell the truth of our stories. And I would like to have your help in welcoming Professor Laura Bazelon, who can share a little bit more of what our learning has been like in the clinic. And I thank you so much for your time.
Hello, everyone. Obviously, it's hard to go after Derek Morgan, so I'm going to do the best that I can, although I think his amazingness is actually the essence of what I wanted to convey here today, which is that the RJA in so many ways turns conventional wisdom on its head. As Derek described, it does away with the holding of one of the most shameful Supreme Court precedents, I think, in the latter half of the 20th century, and says, no, we're not going to put up with the idea that some amount of racism in the administration of criminal justice, even in the administration of the death penalty, is inevitable and therefore something that we are going to tolerate. That's not true in the state of California. We're abiding by a different law. And so because the RJA is saying all of these things that are completely different, it's really quite revolutionary. And in its revolutionary nature, I think it requires a new approach from all of us. And so the people I most want to reach today are people who are practicing, but also the law students, some of whom have been asking questions about what it is that they can do. And the truth is that you can do a lot. And as Derek was alluding to in the latter part of his remarks, we really believe in our clinic that the law students and the younger generation is the future and the energy and the creative motivation behind the Racial Justice Act. And there's much educating to be done in the reverse, meaning that it's really the students and the junior lawyers who are in the best position to educate people who are already established in their careers and in a traditional hierarchical system see themselves perhaps as the people who hold the knowledge and the expertise to be on the front lines and the most front-facing. And we think that the RJA calls for quite a different approach because the best practice when it comes to Racial Justice Act litigation is to manifest the spirit and the animating principles of this law in litigation, which means that it has to be a real partnership based on equal participation from everyone on the team. And I don't believe that there's going to be successful RJA litigation that operates on reifying the existing hierarchies that already plague our profession. Too often, we tell law students that they are small. I think law school is meant to sort of tear you down in that way, make you think there's a language that you need to learn, make you think that your prior life experiences don't hold a tremendous amount of value. And in fact, they're enormously important in RJA litigation because as Derek was alluding to, the kinds of words and terms like implicit bias that people of my generation are learning in MCLEs that were not part of our high school or college or law school experience, those terms are baked into your life experiences. Many of you have experienced them personally and profoundly. And so rather than, I think, continue to talk in general terms, I'll give you a concrete example of what I mean, and I will tell you a story about Derek. So, I am very lucky to teach at the University of San Francisco and to run with my amazing partners at this table and some other folks who aren't here, a racial and criminal justice clinic. And we have been litigating some Racial Justice Act cases. Last semester, we were co-counseling, we continue to, with some very experienced litigators. And Derek and his partner, David, were tasked with doing some investigation to see if it would be possible to prove that there was racial bias and real animus exhibited toward our client by his trial counsel. And the only evidence that we had of this was a footnote in a Ninth Circuit opinion that basically attributed that to hearsay and discarded it as irrelevant to the ultimate opinion. And so, to be honest, I was quite dubious that we were going to be able to get this individual, the defense attorney, to admit that they had in fact been as racist toward their own client as this footnote indicated, although I actually feel like the footnote didn't go into nearly half of what we eventually found out. But in any event, Derek and his partner David, they're both law students at USF. This was their job, was to get in touch with this lawyer and talk to him and see what he had to say. And I will tell you, I was not optimistic about their chances. Not because they were law students, I had a lot of confidence in their ability, but because it just seemed like a really hard thing to get someone to do, to actually say that they had said some things that were pretty terrible. Anyway, I was in the car driving my kids to the pediatrician. My kids have gotten quite a legal education of their own over the years. And I was on mute, and Derek and David their words were sort of like reverberating in the inside of the car, and they're talking to this lawyer. And they just had this very kind of calm, friendly back and forth, and they were just very disarming with this lawyer. And then, I don't know, 5 or 10 minutes into the conversation, he starts just candidly telling them about all the times that he called the client the N-word, hard R. This is an older white man saying the word repeatedly. My children's mouths were on the floor. I almost drove into a median. I couldn't believe that Derek and David were just sort of pulling all of this really important information that later they wrote up in a declaration and had this man sign in this way that was so natural and easygoing. And they weren't confrontational. They didn't take sort of, some kind of competitive there was no face off. It was just as if they were having a conversation. And from the way that they were reacting, it was clear that they were just really, really focused on the task at hand and not personally reacting themselves or kind of giving away the fact that they were getting an extraordinary amount of very, very helpful information. And then the second part of this was really talking to the folks that we were working with, our team, and explaining, obviously you don't have to explain the significance of the N-word with a hard R to anybody, but there were other things that this trial counsel said, and also that his co-counsel said, that were insidious but more subtle. And I think that really the next part was Derek and David kind of explaining further to the entire team kind of the significance of some of the other things that were said and why those also were important in supporting this RJA claim. And so I tell you that story because the most important evidence that's been uncovered thus far in this case was uncovered by 2 law students. And so for the law students who are wondering, what can I do? As it turns out, you can do quite a lot. And I guess I do think back and wonder if we had taken that opportunity away from Derek and David and said, well, this is just too important this is too important. It's too important of a conversation. It's too important of a meeting. The stakes are too high. We cannot let them do it. We're going to do it instead. And they can sit there and watch, and maybe they can contribute. I feel like if we had taken that approach, and honestly, that's the approach a lot of times a lot of lawyers take. With junior lawyers, with law students, they say, it's all fine and good that you've done some research and that was a great memo that you wrote, and I'm really glad I got to kick these ideas around with you, but the stakes are just too high to let you actually do the important things. And the temptation was there, I think, for all of us in the staff in the clinic to do that, and we didn't. And I'm really glad that we didn't, because I honestly don't think we would have gotten the same information. And I honestly don't think that the enforcement of this act is about that kind of a hierarchical distribution of power and responsibility. And what I really hope moving forward with all of us in this litigation is that we see the importance of people who don't have that much experience and maybe don't have the fanciest credentials, maybe haven't been to a courtroom as many times as we have, and yet, and maybe because of that, have insight and experience and wisdom and knowledge that is so valuable. And so I think it's so important when we think about how we're going to litigate and how we're going to be front-facing and who is going to be front-facing, to consider elevating those folks. And I agree with Derek that it also includes all of the organizations and the community members that he named as so critical to reviving this act over and over again when it was on life support, because it's not as if we just say, thank you very much, the lawyers will take it from here. That's not how this works. It's not. A big part of RJA litigation is community narratives. It's explaining what was going on in this county, in this particular situation, in this particular time period. And there are groups in our communities who are much better situated to find that information, synthesize it, and work collaboratively with the lawyers to bring that into court than the lawyers are themselves. And I feel like in the short time that we have been litigating the RJA in my clinic, I have learned more from these groups and more from my students than they have learned from me. And it is really an important lesson in humility and in rethinking the old approaches that we've all been using explicitly or implicitly, consciously or unconsciously. So I will end by saying that I'm very, very, very happy that we were able to sort of model this, because honestly, this is Derek's talk. This is Derek's keynote. This is Derek's life work. He was at Ella Baker doing this before he went to law school. And it's so important that he got to say the important things. So I feel like so happy about that. And also that our clinic is able to partner, and we just found out, I think like 2 days ago, that we got a significant amount of funding to partner with Ella Baker Center, with Silicon Valley Debug, and with OSPD to do Racial Justice Act implementation. And it's just incredible news, very well timed. You should see my budget. And also, I think, speaks again to the model that we want everybody to embrace moving forward, which is that everyone is an equal participant with knowledge and wisdom to share. And we really need to put forward this next generation of diverse and highly knowledgeable people. So thank you very much for having Derek and I speak. And thank you, Derek, for being such an amazing student and advocate. Thank you, everyone.
Thank you all for coming. Many of you I know as little boxes on the screen from the Racial Justice Implementation Group meetings. Wonderful to meet you all. I know it's been a really wonderful morning, and I think it's going to be a great afternoon as well. I'm Linda Starr. I'm clinical faculty here at the Santa Clara University School of Law and co-founder of the Northern California Innocence Project. We at the project have had the real privilege of being involved with supporting the RJA and assisting in its implementation from the beginning, and it's been one of the most rewarding things we've done. It's a real honor to moderate this panel of exceptional practitioners. Many of them have been leading the way in this work for a long time, and many of them are responsible for the successful cases that Lisa Romo was talking about earlier today. So you have a real opportunity to learn from some pros and from those who have contributed to the work in implementing the act as well. It's a large panel, so we're going to try and keep it pretty tight. Each person will speak for 10 minutes. And then we'll have a few moderated questions and then open it up for questions from the audience. I'll go ahead and introduce all the speakers now so that we don't have to interrupt later and maybe get to hear more from them. So we are going to hear from Evan Kuluk. He's a felony trial attorney with the Contra Costa Alternate Defender Office. He's been a deputy public defender for 16 years. He serves on the board of the California Public Defender Association and chairs the CPDA's Racial Justice Committee. In October of 2022, Evan won a post-conviction Racial Justice Act challenge for his client, Gary Bryant, based on the prosecution's use of rap lyrics and racially coded language at trial, securing a new trial order vacating his client's murder conviction and life sentence. In May of 2023, Evan won a pretrial Racial Justice Act challenge for his client Eric Wyndham based on disparate overcharging of Black defendants with gang murder special circumstances carrying life without parole. Big wins. Sujung Kim is the managing attorney of the research unit at the San Francisco Public Defender's Office. Originally hailing from Seoul via New York City, Sujung graduated from Barnard in New York City and USF Law School. After 2 years trying misdemeanor cases at the San Diego Public Defender's Office, Sujung joined the San Francisco Public Defender's Office in 1997. She's tried over 50 misdemeanor, felony, and juvenile cases as a public defender. As the current head of the research unit, Sujung has led the office's RJA litigation effort for the past 3 years. She and her team secured a favorable published decision by the First Appellate District in Finley versus Superior Court, which held that the prima facie showing to obtain an evidentiary hearing under the RJA is a low threshold. Karina Alvarez is the racial justice attorney for the Santa Clara County Public Defender's Office. She graduated from the University of California, Santa Barbara, and Golden Gate University School of Law. She's been a public defender for almost 8 years, and past assignments include misdemeanor trials, preliminary hearings, felony trial team, and conservatorships. She serves on the DEIB committee and enjoys mentoring new attorneys. She regularly conducts internal and external trainings and strives to spread the word about the urgency for racial justice. Currently, she handles RJA data collection, data analysis, expert collaboration, and case preparation, including writs and motions. She has had 3 cases dismissed, either right before or after a prima facie hearing, and she's observed that the pursuit of this litigation, even when we lose, is extremely cathartic for those wronged by the racism in the system. Catherine Grosso is a professor of law at Michigan State University, and as she says, so not a practitioner at all. She studied law at Iowa under David Baldus. Like Professor Baldus, her work focuses on the administration of capital punishment, including jury selection. She arrives here today from the ongoing North Carolina racial justice hearing, where her work with Barb O'Brien provides empirical evidence about the ongoing role of race in prosecutors' peremptory strikes in capital cases. She's been involved in efforts to pass and implement the California RJA for several years. And then we have Arcelia Hurtado. Arcelia is a 1997 graduate of Berkeley Law. She started her career as a public defender at the San Francisco Public Defender's Office, the Santa Clara Public Defender's Office, and the Office of the State Public Defender. In 2020, she joined the San Francisco District Attorney's Office as the Chief of Ethics, Professional Responsibility, Training, Culture, Diversity, Equity, and Inclusion. It's a lot of things. And Post-Conviction Innocence Commission. In 2022, she joined the Prosecutors Alliance, where she is currently the Director of Policy and Training and creates and executes a training curriculum for the prosecutor offices statewide. She's trained prosecutor offices on RJA implementation, including the LA DA's office, the Alameda DA's office, and the Contra Costa District Attorney's office. Welcome them all, and we'll hear first from Evan Kuluk.
Hello, good afternoon. Thank you, Linda, for that great introduction. I'm not going to be talking about either of those wins that were discussed in my bio. I'm actually going to be talking about a more recent case. The Eric Wyndham case that you heard mentioned, we had a part 2 in the Racial Justice Act litigation in that case, and that's what I'm going to focus in on today. I practice in Contra Costa County, which is a big spread out, very diverse county here in Northern California. And in the far east side of the county, we have the city of Antioch. And Antioch is a city that has gone through quite a bit of change over the past couple of decades, and is a city that has a vibrant African-American community. It's also a city that has had significant over-policing. And people may have heard that last year it was revealed that many members of the Antioch Police Department were communicating extremely vile, racist sentiments through private text messaging through their cell phones, their private cell phones, including while on duty. This information was revealed actually during the course of a criminal investigation, a joint operation by the Contra Costa District Attorney's Office and the FBI into criminal wrongdoing by many of these Antioch officers, which included faking college degrees for pay increases. It included very significant civil rights violations, use of excessive force, drug sales, pretty significant conduct that was sort of widespread. And search warrants were obtained. And when the cell phones were recovered from these search warrants, these text message chains that were mostly big group text message chains were revealed. And so last year, the Contra Costa District Attorney released 2 reports that summarized the text message conversations. We had a hearing with a judge for the judge to review those reports and review the text messages to determine whether there was any sort of police privilege, right? Whether this was pitches information that could only be released with a court order and a showing of good cause, or there was any sort of evidentiary privilege. And the judge reviewed those records and said, absolutely no privilege protects this racist language by these police officers. There's no protective order over these reports. They shall be revealed publicly, provided to defense counsel and to the public at large. And so that was in April of 2023. And there were 2 reports that came out. One of them discussed sort of general communication over the course of several years of a racist nature, including many racist tropes and images. And the other was specific to the investigation of a particular case. So in that case, I represent a young man named Eric Wyndham. He and 3 other co-defendants are charged in a case arising out of Antioch, a murder case with gang allegations. They're 4 young black men, all under 23. And it turned out that during the course of the investigation of that case, during the surveillance, that multiple officers were using racist language, homophobic language, sexualized language, violent language to discuss our clients and the investigation. So once these reports became public, we brought a challenge under the Racial Justice Act. And I understand that this is an extreme case. You know, the level of racial bias here is not what we're going to be finding in most of our everyday cases, but I think it's an important illustration to talk through how we approached being able to prove this case in the hearing, in the Racial Justice Act hearing, how we worked with experts, and to understand, you may not be finding this level of racial bias in other cases, but even just a fraction of this can be used and litigated in our Racial Justice Act claims. So the text messages included rampant use of the N-word, animalization, many references to gorilla and images of gorillas, rampantly used. Historical stereotypes, jokes about skin tone and color, joking about inability to distinguish between black men during surveillance, and then during the actual arrests of the clients, plotting to use excessive force, talking about it in advance, and then taking photographs of injuries inflicted upon the defendants and sending them to share between each other and to brag. And then finally failing to follow Antioch Police policy. And we got the policy manual from the police department that had a provision on bias-based policing that required officers to report other officers who were engaging in racial bias or racial profiling. And this impacted the officers who were on these text message chains. Even if they weren't conveying racist ideas themselves, they were being exposed to those ideas and not following the policy to make a report. There's also an employee speech policy. So we filed the initial motion, and the DA's office, rightfully so, conceded that there was a violation of 745A1, exhibition of bias outside of court. So the sole issue in our litigation was one of remedy. And so despite the concession, we argued that the judge had to find the scope of the violation and that we were entitled to present witnesses on the issue of remedy, because there was a concession sort of skipped past the evidentiary hearing. And we said, well, Judge, you have to use your discretion and determine what's in the interest of justice, and we need to present witnesses to do so. And so in this case, the court ruled that 8 particular officers who had sent racist text messaging during the course of our investigation about our clients violated the RJA. Despite our arguments, the judge did not find that the officers who were on those group text message chains and received the text messages but did not report them. The judge found that that was not an RJA violation. But still, we had 8 officers violating RJA. So then the legal question came up, well, if we're only having a remedy hearing, does the defense have the right to present evidence at a remedy hearing? And we made the argument, and the judge agreed that we did, because the court, in fashioning a remedy, has to consider whether dismissing enhancements, special circumstances, reducing charges would be in the interest of justice. And we needed to give expert testimony about the scope and the impact of the violation in order for the court to use that discretion and grant an interest of justice remedy. So we presented testimony of 3 expert witnesses in this remedy hearing. Dr. Michael Mitchell is a professor of African American Studies at College of New Jersey in criminology. He is an African American man who is a former police officer and law enforcement officer in Texas, and then got a PhD and teaches now on racially biased policing. And he testified about the police code of silence, especially about the officers who, in violation of policy, did not speak up. Dr. Claire Kim is a professor at UC Irvine who studies animalization. So she talked about the gorilla images, the other animalization terms that were used, the stereotypes, and specifically the tying in of the history of lynching in our country, and the idea that the photos that these officers were sending, bragging about the violence they inflicted on Black men, invoked the history of trophy photos used in lynchings in our country's history. And then Professor Ian Main, who is at University of Wisconsin Law School, testified about the inadequacies of prior remedies at law before the Racial Justice Act, and why this new law gives the judge an incredible amount of power to actually remedy the impact of bias in the case. So I don't really have time to go through those more in depth, but I have some slides on those. We presented all that evidence, and then it came to the legal argument of what remedy is allowed. And so the law allows for reduction of charges to lesser included offenses. That was part of the questions. What does that mean? And we had a ruling there that reducing charges is not only about 17B of reducing felonies to misdemeanors, but it can also include reducing charges to lesser included offenses. And in this case, we were asking for reduction of murder to manslaughter. And legal research on that there's no separation of powers issue for the judge to reduce a charge to a lesser included offense doesn't violate the DA's charging power. So speeding through, on February 5th of this year, the court issues the order. We got the order granting remedies, and we obtained a dismissal of the special circumstances, all gang enhancements, the gang vicarious shooting enhancements, and a ruling that all 8 officers who violated the RJA could be impeached if they testified at trial. We did not win on the issue of reduction of murder to manslaughter. We were seeking to, the case was charged with special circumstances, carrying life without parole. We were able to get the judge to take off those special circumstances. So now our clients are still facing murder. They're still facing the possibility of a life sentence at trial, but it's life with possibility of parole. We were not able to get as far as we were seeking, which was a determinate maximum sentence for manslaughter. That's my time.
Good afternoon, everybody. Thank you for having me to speak here today. I've learned so much already from all the speakers, and it's great to be with all of you. When I was trying to decide, what to present today, I really wanted to talk about pretext stops. But as I was preparing, I realized there's no way I could talk about it, in 10 minutes and give it, the full justification. But I'll try my best. Actually, my title should not be pretext traffic stops because pretext stops also encompass pedestrians and who are stopped by police with the, where the police officer uses a minor infraction or violation to then search for contraband or arrest somebody. And so, that's what we're talking about when we say pretext stops. We're talking about law enforcement where they use the guise of a minor infraction or traffic citation to then probe further for contraband and look for other evidence of a crime. And this goes without saying, but this is ubiquitous. For those of us who are public defenders, we, reading hundreds and thousands of police reports, we come across this all the time. And even those of you who aren't working in the criminal justice system, it's all over the news. We've seen tragic cases where pretext stops for Black and brown people, could end in death, but it also causes degradation, dehumanization, trauma, which should also be acknowledged. Now, before I start getting into some cases, the facts of cases, I think it's important for us as practitioners to think about how we're going to present evidence of implicit bias in the courtroom. While all of us may be more versed in it and have an understanding, we have to recognize that others in the criminal justice process, including prosecutors, judges, jurors, are not as well versed. And they may feel uncomfortable with just the prospect of talking about race and then talking about bias, or, if we're saying that there was bias in part of the criminal system. And so one thing I thought about is, well, as a jumping off point, there's a new criminal jury instruction that went into effect this year, Cal Crim 209. And it is a jury instruction about implicit bias. The judge instructs the jurors that about the definition of implicit bias, and importantly, it says we all have implicit bias, everyone. And so I think we can use that to say, we're not accusing anyone of racism. That's not why we're here. And Lisa made a point this morning, consistent with that, which is we're here to remedy the harm. We are not here to point fingers. And if we talk about it that way in the courtroom, I think would be more well received. So because Lisa did such a great job of talking about the law, I'm going to skip over all of that. I want to start by talking about different types of evidence that you can bring in a RJA claim based on pretext. So RIPA data. RIPA data refers to a state advisory board of the Racial and Identity Profiling Act. And again, Lisa Romo did a wonderful presentation on this in San Diego last weekend at the Death Penalty Conference. But it is a massive trove of state data that is reported by law enforcement agencies across the state. And it's accessible to anybody. And I don't have time to go into it, but it is a rich source of data for looking at your law enforcement agency, the different, ways they stop people, what basis they stop people. So you should definitely look into that. In addition, police departments often have their own websites, and they also have PowerPoints and other data that they have on their websites, which could be in the RIPA data, but it's more palatable and digestible. And then finally, the Public Records Act, which is a great tool to get information from law enforcement agencies and other public agencies. Whether you're doing a prima facie hearing or an evidentiary hearing, please don't forget to use the facts of your own case to show the pretext nature of the stop. The body-worn camera is a rich source of this. Of course, the police report, but you have to go behind the police report. And the body-worn camera footage will show the interactions between the police officer and your client and other people that will have usually have a lot of great evidence of implicit bias. And then if the police officer has testified in a prior proceeding, like the preliminary hearing, that's another way you can try to present the RJA violation. And then the use of experts, police practices experts, they're definitely should be consulted when you are trying to prove RJA violation based on pretext stop. And then also other social scientists, historians who can talk about the historical patterns of how police use pretext stops and racial profiling, either in your community or statewide. So let me now talk about Young versus Superior Court. Although this, the holding of this decision dealt with the RJA discovery, the facts actually involved a pretext stop where Mr. Young was actually had stopped to observe another police interaction with another motorist, and the police came up to him and started asking questions, harassing him, and it led to Mr. Young being assaulted by the police, and the police found some alleged ecstasy on him. So Mr. Young brought an RJA motion and a discovery motion asking for data about racially biased charging of possession for sale of ecstasy, which is what he was charged with. That's what he asked for. To show good cause to get the discovery, he presented evidence that of a biased police stops. And when he filed the pretrial writ, the AG argued that, look, you can't prove, racially biased charging by showing evidence that the police were biased against you for stopping. Because you're trying to prove an A3 violation, but you're showing evidence of an A1 violation. But the Young Court said no, he can do that because all four types of A1 violations are, they work in tandem and they work together. And so the DA claimed, I'm sorry. Okay. All right, I'm going to move on to the next one. Okay, I'm going to talk about Finley versus Superior Court. This was the case out of my office, San Francisco. This was another pretext stop where the police officer was driving down the street and decided to check Mr. Finley's license plate for no reason at all, but that he was driving in a quote-unquote high crime area. So he wrote this in the police report. He testified to it at the preliminary hearing. We brought an RJ motion, and we had an expert witness who used to train SFPD in anti-racism. He was an anti-racism trainer, and he testified that the term high crime area or high crime neighborhood was a racist trope historically used by law enforcement as a pretext to in Black neighborhoods in particular. We also had SFPD's own data, which show that they stopped Black motorists at a rate of 8 to 1, that they stopped white motorists. And we also have body-worn camera footage showing the police harassing Mr. Finley and his family. And so based on that, the trial judge initially found that there was no prima facie case made because just like the judge in the Bonds case, which I'll talk about in a minute, he said, I don't believe the officer saw your client, that he was Black. So basically, the judge did not understand implicit bias. He was looking for signs of explicit bias. So we took a writ, and the Court of Appeal issued a standard for prima facie and remanded it back to the trial court. A couple of weeks ago, we had a rehearing, and the same judge, he had, under the instructions given by the Court of Appeal, did find that prima facie was established. So we now have an evidentiary coming up. And then the final case I'm going to talk about is Bonds. Now, Bonds was another traffic stop where Mr. Bonds was driving down the street. The officer was driving the other way, and the officer decided to make a U-turn and pull over Mr. Bonds. And, Mr. Bonds said, hey, why are you stopping me? I didn't do anything. Is it because I'm Black? And he was very upfront with the police officer, and the officer said, no, but, I saw that you're wearing a hoodie. So, and then, eventually he found a gun in the car. So Mr. Bonds introduced three different expert witnesses at the hearing. One was a San Diego State professor, researcher, who had introduced evidence of 4 independent studies about San Diego Police Department's racially biased stops. They also had a police practices expert who reviewed the body-worn camera footage in that case and concluded that the officer's conduct was consistent with racial bias. And then finally, there was a sociologist who talked about the term using hoodies, and that's a kind of coded language that is connected with criminality with people of color. The trial judge in that case denied the Racial Justice Act violation, basically just like the judge in Finley, saying the police officer didn't see the person's race. Therefore, you didn't prove the violation, completely ignoring or or not taking into account implicit bias. In fact, the trial judge pretty much disregarded all the expert testimony. And on the writ, the Court of Appeal said, the trial court should not have disregarded the implicit bias, and the implicit bias evidence is absolutely essential in this racial justice act violation. And it was interesting. The opposite of Young. So in this case, in Bonds, it was an A1 violation, but they presented evidence of A3, and the court in this case again said all the violations work in tandem, and that you don't have to prove that it's a violation of A1, A2, A3, or A4 at the prima facie stage. And so they remanded that back to the trial court for a rehearing. I think I'm way over my time. I'm just going to say one last thing, which is that in San Francisco last week, we had a pretty major victory in this front. The police commission passed a general order prohibiting the San Francisco Police Department from stopping people based on 9 different types of traffic infractions, including things like broken taillight, failing to signal, failing to signal within 200 yards of a stop sign, things like that. And so this new general order goes into effect in 90 days. And this was a historic victory because we've been working toward this for years. There's also a legislation up in Sacramento that is trying to do the same thing as the San Francisco Police Commission did. I was going to talk about one last case, but I don't have time. So thank you for your attention.
Hi, everyone. My name is Karina Alvarez, and I handle pre-conviction RJA cases at the Santa Clara County Public Defender's Office. You've been hearing a lot about the RJA and what a landmark case it is. If you were at any of the other conferences, you also heard how unprecedented this is. And I can't really emphasize that enough, and I want to start there because in addition to the McClaskey v. Kemp history, which is a powerful one, this is something that practitioners have been fighting for years, decades. It is a known fact, I would say, among practitioners that prior to the RJA, when you brought up the words race, discrimination, slavery, certainly, genocide, colonization in the courtroom, there was palpable tension. When we had conversations with our client and we saw on the body-worn camera video that someone was disrespected, but we just saw another video with a non-person of color that wasn't disrespected, there was no recourse. That conversation that we had with that client was more centered on, is there a Fourth Amendment violation? What do the facts of your trial look like? What are the remedies? What are the offers we're going to seek? It wasn't you have been oppressed and there was exhibition of bias and we have relief. And now we do have that conversation and it's a very rewarding one. So I'm going to concentrate on working with experts. And I want to start with what we know. The headlines, these are Santa Clara County specific headlines, but the headlines all over the state and nationwide point to discrimination, inequities, segregation in our community. And we see these headlines time and time again. When I assemble exhibit packets for motions, I look at the articles and it's 1988, 1995, 2004, back again 2006, and so on. The headlines are the same, yet nothing changes. This is a call to action for practitioners, certainly, but judges, prosecutors, everyone in the community. So We know that we are talking about bias here, and the law, as Sujung noted, was explained by Lisa Romo, so I'm not going to get into it again. But there is an emphasis on bias here, specifically implicit bias. The legislature in AB 2542 and its declarations and findings actually went as far as saying we all have implicit biases. The legislature has declared that. So I think it's okay for us to accept that and recognize that, because it's really the first step at ameliorating these biases. And we know also from the legislative intent that courts have for a long time been addressing only overt bias, not insidious bias that has really infected our system. I work with Dr. Jonathan Gomez, who is here, professor at San Jose State University, and he said something I found really powerful. And he said, punitive interrogation masquerading as cultural curiosity. So that is something that I see a lot between officers and clients. And I'm going to say it again, punitive interrogation masquerading as cultural curiosity. We see an exchange between an officer and a client, and we wonder, why is this officer asking him what language he speaks at home, or why he wears the color blue, or how many children he has? These are the more subtle forms of bias that maybe if you're not a person of color, you may not pick up on. This emphasizes the need for experts. We know that implicit bias lies within the reptilian brain. It bypasses consciousness. So the speaker is not aware that they are making it. That's why it is absolutely correct and important to take racism out of it. While that unconscious bias may be truly unconscious, what got that unconscious bias in that reptilian brain is racism. So that is why it's so important to back up these claims with qualitative data detailing the historic oppression of BIPOC individuals. So 745A3 and A4 are more data, they're data-driven claims, right? So not bias. However, this is straight out of the statute. We can use statistical evidence, and we can also use qualitative data. This is really important as we have to be storytellers. We have to explain why we don't see policing in affluent communities. We have to explain why we don't have the data to explain that there is replete drug use in communities that the police just aren't visiting, right? And yet in low-income communities, there's an over-policing. So that data, that creates a data problem. You can use qualitative data to enrich your motion and educate the bench and educate the prosecutors in explaining why this over-policing problem was created in the first place. And it's in the statute, so quantitative and qualitative should be used in conjunction. So this is our process at our office. We find a case, we engage in the discovery process if it's data, we find an expert, there's a case-by-case analysis, of course, then we write the motion and file it. Finding an expert is an essential part of your case. It takes a very detailed deep dive into your case because not every case is going to have the same experts. I think when RJ started, we were all very excited about people like criminologists and law and society and legal analysts, but when we became more granular about it, we realized, okay, here maybe we need a linguistic expert, or here maybe we need a sociologist. So it really does depend on what type of case you have and what the bias is. And also think creatively. So I'll share that I have a case right now. It's what I believe is a pretext stop, just like Sujung was astutely pointing out. It's a a violation of Penal Code 148, resisting. And the client in that case, who is a person of color, his medical needs were ignored. So in addition to it being a pretext stop, one of the first things he said to police was, I have anxiety, I have a heart condition. The police officers proceeded to ignore that and hold him at gunpoint for walking on the street. So instead of going to the usual, maybe law and society professor or a professor that is well-versed in police conduct, I went to somebody who had knowledge about medical bias. And the reason for that are names like Eric Garner and Elijah McClain, because these are individuals that have been investigated by police, whether it's a pretext stop or otherwise, have explained or communicated medical needs, and those medical needs were ignored. And we know the rest of the story, right? So I think it's important to be creative and to gather information in a way that's really going to enrich your motion. So, like I said, this is a very short list. It's not exhaustive by any means. These are just, I would say, the more popular type of experts that I see, linguists, sociologists, and so on. I really want to emphasize community expert because community experts they can be a very rich source of information. So community experts would mean something like, you know that a neighborhood is over-policed, you know that a neighborhood is very diverse. Tell the story of that neighborhood with community leaders. So these are some examples of out-of-court bias. So these are focused on 745A1s. I think a lot of times I see on the listserv or I get calls from colleagues in other counties and they're looking for a list. Do you have a list of implicit bias terms? Do you have a list of things that amount to implicit bias? There's really no list. It's very subjective. As others have noted, it really depends on your own experience and what you pick up on. These are some that we have in Santa Clara County at my office. So a law enforcement officer mocks a Latinx client's perceived accent. And I say perceived because the client did not, in fact, have an accent, but based on his appearance, the officer started talking with an accent himself. He asks about gang membership based on the client's cultural attributes, like the kind of hat that he was wearing and a tattoo on his arm. Another example is an officer calling a Black woman lazy for not blowing hard enough on a preliminary screening device. Another example is an officer calling a Romani or Romanian person a gypsy and saying that gypsies at Costco lie and steal all the time. So there must be credibility lacking in her story. Another example, an officer racially profiling the client and what I call reverse code switching. And what I mean by this is he is using a type of vernacular that he is projecting onto the individual. So in this case, the individual, the client, had not spoken a word. He was sitting in his car. The officer comes up to him and starts speaking to him the way that he expects him to speak. In this case, it was, "What's poppin'? You all iced out." And simultaneously speaking to his white colleague in a different vernacular. This man was white. So this case was dismissed. We had a great declaration from an expert, and the case was rightfully dismissed. Charging disparities, you will also, of course, need experts for data scientists, data engineers, and whatnot. These are some of the disparities we are addressing here in Santa Clara County. I'm not going to read this whole thing, but Evidence Code 720 lists what makes up an expert, and it's actually not what some people might imagine. You have to require some subject matter expertise, but it's perfectly acceptable to have somebody that doesn't have a PhD or a master's degree or so on. So more good news for cultivating those community experts. Finley also talks about experts. I would say that the takeaway that I want you to have from this slide, instead of reading all of it, is specificity. So when we work with an expert and we have that expert draft a declaration, we want to focus on specificity. It is not the task of the expert to deem the entire thing bias or discriminatory, but we want to know exactly what makes up the bias. Quotes, timestamps from body-worn camera video, precise sentences, and applying that expert's knowledge and some analysis, right? So that way we can meet the Finley standard, and the judge who is serving as a gatekeeping role can know that your declaration is not conclusory because it has specificity. The other thing I want to talk about that's critical for working with experts is burdens of proof. So for practitioners, be aware that burdens of proof are wildly different in social sciences. So the psychologists in this room might know that it's worth your time as a practitioner explaining what the burdens of proof in the legal field are. I've noticed that data scientists and social scientists work with a lot more certainty than we do. Clear and convincing versus beyond a reasonable doubt, for example, is very, very different than what they're used to. And lastly, get creative. Research the experts' work, research multiple experts' work, read their articles, find the study that you need for your client, and most of all, tell the story. The RJA is a landmark piece of law that really allows us to finally bring dignity, not only relief, but dignity to our clients' stories and the racism that has persisted for so long. Thank you.
So clearly, I'm not a practitioner. I must sometimes be an expert. I'm not sure. I think I'm a Law and Society one, though, so I'm not sure I'm on her list. So I just have to say, just that for starters, that it is such a delight to be here at Santa Clara, to meet so many amazing lawyers who I've only known on Zoom, who've been working to implement the California Racial Justice Act. The California RJA is a vote for the power of law to make change. That's what I believe. It's a power to find justice and to demand justice from our legal system. And I feel really lucky to just be a part of it. I love the work you all are doing, all the ways you're trying, these amazing lawyers who are just so creative. So I thought it might be, as I said, I'm a law professor, I'm a legal researcher. I worked often with attorneys who are seeking to prepare or understand data about the influence of race on charging and sentencing or on jury selection, as you heard. And I'm honored to sort of share the stage with these guys. I thought it might be most helpful for me to use my time to share some of my own research, to talk about the process for developing a study. So now we're deep in A3 and A4. We're done with A1 and A2. Those ones are kind of easy. Not really. But trying to figure out, like, what do you do with the study? So our research, which some of you may have seen on the administration of capital punishment in California between 1978 and 2002, has resulted in 3 sets of findings. And I want to talk about how we collected and prepared the data in this study, and also just share a few of the most recent findings. So one of the first points of contact between a researcher and lawyers, what happens when my phone rings, right? When I pick up the phone is, what do you want to know? What is it you want to know? And it's the research question or the reference question, sometimes it's called. And really, the lawyers are the expert on that. You know the legal issue that has to be addressed. So there's nothing magic about it. We just have to talk until we have it. Here are 2 different reference questions, 2 different questions that we were designing studies for. Once you have a the reference question, you get a flood of questions, like so many things that come next. Think about, what different ways could we answer the same question? What have different scholars done to get at this idea? What are different data, and who has them, and what form are they in, and can I get them? How are you going to have the money to turn pages and pages of transcripts into a database? All of these things. You don't have to take a picture of my slides. You can have them, honest. I'll give them to you. So all of these things. The bottom one, the last question, is a really, I say that to my students all the time. I'm so sorry. You can take pictures. The bottom one is really a key one. What are the things you can anticipate are going to be challenged? What are the things that are going to get extra scrutiny? What's going to be a problem? And what can you do to shore that up? In our jury study that we just presented in North Carolina, again, we double coded. That means 2 people read every transcript. That's crazy in terms of scientific evidence, but it's what you do for litigation sometimes. Next one. So this study was about charging and sentencing decisions in California homicides, and it was really developed to answer the first research question that I showed you before, a Furman challenge that was brought in the federal habeas case of Troy Ashmus and Jerry Fry in 2010 here in California. The habeas petitioners maintained that the breadth of California's statutory special circumstances, combined with its extremely low death sentencing rate — I'm going to show you both of those findings — meant that it was unconstitutional under Furman, right? That it wasn't doing the narrowing that was required under Furman. So the goal of the study was to assess the narrowing effects of California's post-Furman law among all factually willful homicide cases. It had to necessarily not be only the ones that were charged as first-degree murder. So you had to find good facts. We defined our universe as all defendants convicted of first-degree, second-degree, and voluntary murder and voluntary manslaughter. We obtained a list from CDCR of these cases, and the list had 27,453 cases that fit our time and our crimes. And so then, freak out, right? You can't code 27,000 cases. Even you all can't. So we took a random sample, very carefully, and ended up with 1,900 cases. The petitioners then used discovery motions to obtain probation reports under very strict protective orders, extremely restrictive, how they could be used and how they could be shared. And most of the time, the probation reports contained very rich factual data. But when they don't, we had a protocol for that. So what happens if you open the probation report and it's got nothing in it? They would throw the case out and pull a new random case. But what if it's got half the information? There was a separate protocol for how do you fill in the missing information? Do you use an appellate opinion or not? Which times can you use the media or not? There are rules for everything. The original team, of which I was not a part, my dear mentor, David Baldus, wouldn't let me work on this because I didn't have tenure. And he's like, you will not get tenure on this. I was like, okay. The original team completed a 55-page questionnaire for each case. So all the data coding is answering questions, and theirs was long. When the probation reports, I already told you that. So the goal was to maintain the highest level of factual completeness. Every choice was about the factual details because we had to figure out how the law would have applied. Not how it was applied, but how it would have applied. So it took nearly 2 years to complete the coding and another 18 to verify it. The study needed, as I said, to look beyond the cases that were capitally prosecuted to map the factual reach of the case. It's possible, as I said, to characterize a death-eligible cases that resulted in second-degree murder or even voluntary manslaughter as death-eligible. For example, think of defendants who plead to a lesser sentence. But at the 2010 proceedings, the state argued that such cases cannot be death-eligible under the statute. That dispute turned on the quality of the factual evidence in the study. Right? We anticipated there would be that dispute, and we prepared for it. This study, the findings in this study were published in the Journal of Empirical Legal Studies, which is a top quality peer review study after David Baldus died. So this is his study. And here's the first one. You've probably seen this before. This is table 1, and it shows, each line shows the percent of cases that are death eligible in column C. Like this column here, column C, under each regime. So the first one is pre-Furman, Georgia. That's the world as we knew it, 100%, right? There was total discretion to bring any cases capitally or not with no justification, just your gut. This is the death eligibility among murder 1 convictions. So one part of our cases are murder 1 convictions. You hear that cited pretty often. 95% of first-degree murder convictions are death eligible in your state. But then this bottom one, which just quickly, 86% of the factually first-degree murder cases are even death eligible. It's a huge and broad statute. And the other part of the statute is, of course, that nobody gets death. All right, so the level of discretion in this in your system is far lower than the 15 to 20% death sentencing rate that they threw out in Furman as arbitrary. So it's a particular look at your death statute here in California. So these 2 slides really just provide a brief look at how this research sought to answer that reference question and what special efforts we took to try to make it work. But I also want to show you about the race study, which is the brand new study that is past 1 round of peer review. So hopefully it'll be out soon. It's not accepted yet, just like this close. So one of the challenges of using the same data source, the same database for a race study is that the probation reports don't consistently report either race or name of victim. So we had to go back. The OSPD funded an incredible effort to go back and collect both 100% of the defendant race and ethnicity and all but 5% of the victim race and ethnicity. So first we had to get all the names. I can tell you how we did it anytime you want, but not now. And then we used the death registry to find the race and ethnicity of every victim. For the remaining cases, so I told you there are 5% of the victim cases that we didn't find a race for. And in that instance, we told the computer to consider them non-white. So just assume everyone we don't know about would be on the non-white side. This made our estimates of the racial influence on cases and decisions and outcomes more conservative, right? It made our study conservative. This was kind of on purpose. It reflects a decision in the design, a preference in the design to understate rather than overstate the disparities. It assumes the best where possible. It tries to give credence to the decision-making of the court, of the state where possible. Again, this has to do with presenting the study in court. But this has to do with being able to articulate those conservative choices as a way to say, we're not overstating here. So I think this research has been used some in policy decisions and in informal presentations, but I don't think it's been in court yet. I think it might be soon. It's under review, as I said. The next few slides, which I'll go through really fast, I'm almost done, show just a little bit about the findings, but I want to tell you two things about them before I show you show them to you. The paper has 22 slides and I'm showing you 3. So it's just a glimpse of what the findings that we have. But in every slide, I'm going to show you odds ratios. They're all odds ratios from controlled logistic regression models. I'm not showing you the models, but the control, I used the ones I'm showing you are the more conservative tables from my paper that control for defendant culpability using a scale that ranks the cases from top to bottom using, 9 different kinds of detailed information about the case. Just the things you think I would control for if I wanted to rank them top to bottom. I can tell you more about that too. So in each case, I show you the odds. The odds show the ratio of the probability that the event of interest occurs to the probability that it does not. Don't panic. Here's an easier way to say it. An odds ratio of 1, you wouldn't bet on anything, right? If the horse had the odds of 1, the team, that's what you bet on now, right? The team had an odds of 1, you wouldn't bet on it. But an odds ratio of 2 means there's a 100% increase in the odds of a black defendant receiving a death sentence. So we want a 1, and everything over 1 suggests a disparity in what I'm showing you in these slides. So this slide presents the race information of the relative odds of receiving a death sentence. These findings stand alone, almost alone, nationally in their magnitude and their consistency. Even after controlling for relative culpability, black defendants in California between 1978 and 2002 faced 4.6 higher odds of receiving a death sentence than everyone else. At the same time, Latina or Latinx defendants faced 3.2 higher odds. These are unheard of disparities. These are California specials. These are not what I've seen in other studies. The white Vic one on the other side of the screen, that's normal. That's what usually drives capital punishment in our country. In the studies I've seen. Shocking. These disparities stop me in my tracks every time I see them, and I want you all to hear them that way. Like, these are shocking disparities. Other recent research in California has replicated them, so they're not wrong. They're right. It's true. All right, 2 more slides. Figure 3 reports on the prosecutor's decision to file special circumstances in the case, and it compares cases with at least 1 white victim to all other cases. So this finding, again, parallels what we see around the world, or around the country. And the last one is about jury sentencing. And one of the surprises in the California system is the extent to which the race of defendant discrimination happens at the jury decision point. Ties to a lot of what you're thinking about the need for the Racial Justice Act in all kinds of ways. This is just the interaction. This is just the black defendant, white victim, Latina defendant, white victim, and white defendant, white victim cases. And once again, you see just really big disparities. These are the kinds of analyses that are possible when you code data like this. But it took years, and it takes a lot of money, and it takes a lot of time. So I think I don't want you to think that I think you only have to have a study this complicated to say something real. I think that we can show racism in all different ways if we just are careful, and we're thoughtful, and we're transparent about what we didn't do. So my last slide, keep thinking. Don't learn the study 100%. That means fully understand the data, the methodology, the conclusions. Ask hard questions of your experts. If they can't explain it to you, they certainly can't sound good in court. Like that, you just have to. And you all are smart and capable and can do it. Be prepared with the law. It's your job in a study, not the expert's job to know the law. It's your job to know what the legal question is. And prepare for it to be challenged, because it will be. They will say everything wrong. They will say you didn't code for the right things. But hopefully you'll win anyway. All right, enough.
Good afternoon. Are we still alive out there? Yeah? All right. Well,
Thank you so much for inviting me to be here. I think I was invited to give you the prosecutor perspective on the RJA, although I'm not a prosecutor, I'm not a practitioner either. Although I did have the privilege of being a public defender for 10 years and also a prosecutor for almost 2.5 under Chesa Boudin, who's here with us today at the SFDA's office. So, and there are prosecutors in this room, and I encourage you to talk to them about their work. Prosecutors are here from the LA DA's office, the Alameda DA's office, and I think they're here, and we're all here in the spirit of learning how to implement this really important piece of legislation. So I just wanted to start with that. So what is the Prosecutors Alliance of California? What we do is we support member offices, member prosecutor offices. We're a reform organization, and we support our member offices with technical support. We do legislative advocacy work in Sacramento, and we do training statewide. And that's primarily what I do, is training for prosecutor offices statewide, including training on the RJA. Now, what I want to share with you about the Prosecutors Alliance is that SB 50, the pretext stop bill, that was sponsored by the Prosecutors Alliance. So, thank you. It was defeated largely because of opposition from traditional prosecutor organizations like the CDAA and also police unions. So that is the reality of our landscape that we're all operating in. So I just want to give you that context as I tell you about some of the work that we're doing, and also some of the challenges that I see from having trained various prosecutor offices around the state on the RJA. So how do I advance this? Okay, so some of the challenges of implementation. It's getting better, but there is a lack of uniformity in data collection. So in other words, different law enforcement agencies, prosecutor offices receive discovery requests. There's a lack of uniformity and communication between law enforcement agencies about data, and so the data is not always there, or it's not in a format that is comprehensible or uniform or usable sometimes. So that is one challenge that I've seen. The Prosecutors Alliance has also sponsored a legislation to improve data collection across law enforcement agencies that make it more uniform. So that's another part of the work that we're trying to improve so that we all have the data that's needed to evaluate some of these claims. Again, we do training for offices, but I've seen that many offices across the state don't have training for their prosecutors about how to evaluate these claims, how to litigate them. So that's a big challenge that we're trying to solve. But that's another one that I've seen that's impacting the work. There's a scare. I've seen that prosecutors are often, unlike our defense attorney friends, they're very creative and are able to find experts that are needed and can really drill down into what's needed in a particular case. Sometimes prosecutor offices are not as creative because that's not their job normally, is to try to find an expert to substantiate, the use of certain words in a case, right? That's not usually something that prosecutors do. So what I'm saying is that many times in trying to evaluate some of these disparity claims in particular, it's difficult to find qualified experts because many of them have already been retained by the defense. And I've seen that happen many times. So part of the work that I do is try to find experts to help prosecutor offices evaluate the disparity claims. There's also a nature that we all know that is in the criminal legal system where it's adversarial in nature, right? So many times when I'm doing trainings for prosecutor offices, what I'm trying to impart most importantly sometimes is that the RJA is a prosecutorial ethics issue that they have to view not in an adversarial way, but in a prosecutorial ethical duty way. And that is really difficult to make that mind shift sometimes because we're used to being adversaries in the criminal courtroom, right? And then finally, there's a lack of resources, not least of which is that many times we're relitigating, especially with the post-conviction cases, we're relitigating, let's say, an RJA claim that happened many years ago, and that impacts victims and survivors of crime. And prosecutor offices do not have the resources to really provide the support that is sometimes needed when victims and survivors of crime are reliving some of these facts of their case. So I want to end with a very important part of what the Prosecutors Alliance does. Oops, there we go. So these are some of the things that we do to help implement the RJA from the prosecutor's perspective. So I talked about the statewide trainings that we've done for offices. We've also created model RJA policies for offices that to suggest how they can handle these claims in a more equitable way. We host a monthly work group for prosecutor offices that are interested in coming to talk together about what the challenges that they're seeing, how they're handling them, etc. And then, we also maintained a shared resource, a library, so that prosecutor offices and prosecutors can share case law, briefing, experts, model policies, etc. But I want to talk about one part of the implementation work that we're doing that is the most important part of RJA implementation. And it's not up there, but it's expanding the pipeline. Why is it important? How many people in here are students? Can you raise your hand? Okay, great. Thank you for spending your Friday afternoon with us. I will tell you, when I went to law school to be a public defender. I had no inkling in my mind that I would ever be a prosecutor. And I blame Chase Abudin for that. He's the only reason I became a prosecutor. But what we really need is a pipeline. We need a pipeline of students who will consider being a prosecutor. And why is it important? What I will tell you from having worked as a defense attorney and as a prosecutor is that prosecutors do have a lot of power. When a prosecutor concedes a claim, an RJA claim, and won't litigate it, concedes that, yeah, that's a violation. That's really powerful. That is incredibly powerful for someone to do that. So who do you want to be making those types of decisions? So some of the work that we do at the Prosecutors Alliance is we're creating law school chapters. We have one at USF. We have one at Golden Gate. We have one at Santa Clara. And what we're trying to do is build a pipeline of students who will consider a career in prosecution. I'm not saying it's not important to be a public defender. Absolutely it is. But it's also important to have a diversity of perspectives on the other side who can hear what these claims are about and who can validate them and who can concede them when it's important to do so. So anyway, that's all I have. Thank you for your attention and
I was going to ask each of our panelists certain questions, but given what they presented on, I think there's an overwhelming emphasis on the importance of experts in their cases. Every one of you talked about cases where you use multiple experts in different ways and how to be creative. And I want to talk about that a little bit with you all. Let me start with you, Evan, because you're right here. Okay. How do you identify the right experts that you want to present?
So across the 4 main Racial Justice Act hearings that I've litigated, I've now worked with 6 different experts in a variety of different fields. And starting out with the Bryant case, which was very early on in the RJA existing, I looked to the social science research. This was a claim regarding the use of rap lyrics, the use of racially coded slang. And so it was truly a matter of cold emailing academics. 2 out of 3 of the expert witnesses in the Bryant RJA hearings never testified before. I said, I'm no expert witness, that's what I do. And working with them to understand, like, you're the person who can do this. We don't have RJA experts yet. We have to cultivate them. And it was very powerful, I think, for those academics to have that experience. Professor Mary Bowman, who's at ASU Law School, she testified for the first time ever at the Bryant hearing, and now she's testified a good handful of times and has really become a statewide expert on prosecutorial rhetoric, implicit bias in racially coded language by prosecutors in trials. In the case I talked about today, the Wyndham hearings, Carmela Carmano, who's one of the other attorneys on that case, did a lot of work as well, reached out to more than a dozen people to get to the experts that we found. And again, 2 out of 3 of the folks who testified in that hearing had never testified before. And they testified and they were willing to take the case because we approached them to say, the research you've done, you are the right person. You're the voice to explain to our judge, what does this mean? What does this language mean? How do we understand the police racism in this case? And thinking specifically on that issue of remedy, how do we show the judge the scope of how impactful this was? And we're asking for something huge. We're asking for a murder case to be reduced down to manslaughter. And so specifically thinking, okay, well, we want to address the blue code of silence, the police not speaking up, protecting each other, allowing the racism to go forward. We want to address the historical context, the history of lynchings, of animalization, of all those terms and all those racist stereotypes being used. That's not just some officers, making up something right now. They're invoking long history of racialized violence, that type of language that gives permission to enact racialized violence. And so it was truly a matter of finding the folks who are doing the work and telling them, you can do this, and doing a lot of prep for understanding what cross-examination should be like. A lot of these experts never been cross-examined by a prosecutor, and that was a very scary thing. So taking that time, and folks in this room have done a lot of work training experts and calling experts together and empowering them to say, you can do this. Just because that's not how you see yourself as an academic, not as an expert witness, doesn't mean you can't do it. And we've had some incredible successes in cultivating folks based on their expertise and not based on them advertising themselves as being an expert witness.
Thanks. Karina, I have a question for you about experts too, because you made a lot of reference to them. Do you see in working on these cases times where you don't need an expert? And what are those times?
Yeah, is this on? Yes, definitely. So I will say that my gauge was if something was overt, I would not need an expert. So I can tell you that, so it's a 2-stage process, right? There's the prima facie hearing and then the evidentiary hearing. So we recently had a case where a sergeant referred to Romani people, as I said on the slide, FGC, and associated Romani people with criminality and untruthfulness and lying and scheming. So in that case, I decided, well, one, I couldn't find one. They were largely in Europe, and 2, the ones over here were all on the East Coast. So clients in custody would have to move fast. But also I did find the terms to be very overt, and the burden of proof is very low, as stated in Italy. It's only more than a mere possibility. So I decided not to use an expert. However, we'll say that there have been times that I didn't think that I would need an expert, and I got an expert anyhow, and I still lost. So that kind of sends a message of, hey, what's going on here? But, I'm hopeful.
Catherine, you're an expert. What can you tell us all about working with experts that might not be obvious to us? It's all obvious to you all.
I think you probably would have no idea how often I talk to lawyers who are thinking about doing this kind of research, and that Professor O'Brien, Barbara O'Brien, and I hop on the phone with anyone doing a jury study anywhere in the country. We're happy to do it, and that's same for experts you're trying to talk into doing work. So I think that's one thing, and the other thing is that part of So it's one thing if it's like a subject matter expert, but if you're gonna ask someone to do an empirical study, you're gonna get the result they get. So I've been asked to do analysis for people and I've told them this database doesn't show discrimination, doesn't show disparities. And that's part of working with experts, because our job is to tell you the truth.
Sally, I have a question for you too. You've talked about the difficulty in finding experts as a prosecutor. Do you ever just accept what the defense experts say?
Well, if it's overt, that's, I would assume, I would hope, right, that most prosecutors, if something's pretty overt, you would concede, and I think that that's what we're trying to work towards, right? Is this common understanding of history of why we have the Racial Justice Act, the legislative intent, why, how to evaluate these claims. And I will say there is a little bit of resistance sometimes where people, prosecutors feel like they're being personally blamed for the history of our country, right? And I think that you have to take a step back from that so that you can fairly evaluate some of these claims without feeling like, oh, I'm being accused of being racist as a prosecutor. So I think what would help with that automatic kind of like feeling that sometimes people get a feeling accused, I think it would help to have expert testimony to help evaluate, because your job as a prosecutor is to evaluate a claim and do it fairly. I mean, you're not representing any side, right? Presumably, by the ethics rules, you're representing the community, the entire community. That includes the defendant. So you want to be able to fairly evaluate claims. But sometimes, like the statistical disparities, you're going to need an expert. And I think it's our responsibility to do that. Personally, I know the history of race as a death penalty, so my inclination would be to concede something like that, of course. But but that's my personal opinion. But as a lawyer, of course, you want to be able to have some foundation for your actions, and not just they would be as bad as if I was deciding something based on my own biases, right? So you don't want that, and so you do want an expert, I think, so to be sure that you're being fair.
Can I just add, I thought what you remarked about the adversarial system is just so true, right? The job of the prosecutor is to be adversarial to the study. And so you end up having these bizarre conversations about the study where maybe a different process sometimes is what's needed. Like maybe it's not well suited sometimes, right? I think you're really right, but it's possible. As these jury studies, right? These jury studies, you can't find something else with data. The prosecutors, experts can't find something else. So they say crazy things. It's not helpful. Judge Sweet was impatient, saying stop asking that cross-exam. That's not what we're about. Get to the meat of it. Still didn't really get to
We have time for questions, or are we gonna go a little longer? Or do I end? Do you have some questions from the audience? Of these amazing practitioners and experts?
Yeah. So since there is a lot of offices here representing public defenders, have you all considered doing more work with community providers for defense? I love the way that you all broke down a lot of the practical steps. Have any of y'all thought about that before starting this work?
That's great.
Hi, yeah, so we originally.
Can you repeat the question?
Oh.
We can't hear.
His question was, since there is a good representation of PD offices, public defender offices, have we thought about working with participatory defense groups and expanding our networks? And I can speak for Santa Clara County. I routinely work with Deepak here, Silicon Valley Deepak right there. They have been amazing. They're a rich resource for our day. So yes, we routinely work with them. They come to my hearings. They support our individuals that are joining the hearings. So yeah, we definitely believe that. We also, I'm pretty involved with Heafey, also another amazing group that helps together.
Yeah, I was trying to reference more in the Central Valley because that's where we see a lot of the lack of that. like anywhere, basically, moved away from this area, there is not that. So would that be something that officers can help out with? We do look at detail as well.
Could you repeat the question before you answer?
The question was, how about that same sort of effort being made in the Central Valley? There's a real lack of that effort being made in the Central Valley, and is there some way that people there could be supported with this kind of effort as well?
Yeah. On the prosecutorial end of things, how much involvement is there from the Attorney General's office, or try to get them involved in some of this?
We work closely with the AG's office. They're part of our work group, our School Justice Act work group. And, I can't speak for their policies on RJA claims, but, I think that there is a real commitment to enforcing the RJA and implementing it in a fair way. So I think, and that's part of the work that we do, right, is trying to move things in that direction, because that's what the legislature and the people that enacted this law want us to do. But I think I see it as more of a lack of education sometimes when things don't move. It's really a lack of training and a lack of understanding of what the law is trying to accomplish. But we're working on the training aspect.
For community experts, does that mean going to find someone who's lived in the neighborhood like 50 years, or are you looking for more academic when you say community experts, someone who's done research?
So when I use it, I'll speak for myself. When I use it, I need not an academic, somebody who's lived in that community, has seen a change, has seen the gentrification, and somebody that can speak to what it's like to live there. 50 years is something we're aiming for. We've actually been in touch with people, well, through Deepak, that have been there even longer. So those people hold a lot of information.
Thank you.
Anybody else?
That's Mike.
When it comes to the data with the RJA,
Mike's coming to you. Here comes the mic.
thank you. Is there a way to get like the data from your study down to a county level? Because that's what's needed for these A3 and A4 claims.
The data I was talking about?
Yeah.
No.
Okay.
But I agree that we should be on their own studies, and that are worthwhile to do. Just gotta find the data, find the sources to create the data.
Thank you.
Yeah.
You brought up the point about the district attorneys feeling accountable, responsible for the injustices in the defense. How do you handle that with the jury? In the same situation, jury trial, and to bring in an expert evidence to testify about the situations, might they feel a little defensive about them? You're talking about racism, etc. Anyone has experience with that?
That's the trial lawyers.
How do you mitigate?
I'm pretty sure. Right. How do you guys do? Is that what you just read? We should sort this out. Escape.
So if I understand your question, you were asking how to talk about racism in front of a jury without alienating them?
Correct.
Okay. It's definitely a tough one. As I stated a little bit earlier, there's a new jury instruction about implicit bias that the judges can read to the jury. And what it tells them is that all of us carry implicit bias because of the culture we live in. And so I think the idea is to let people, have people let down their guard and understand that we're all in the same boat, that nobody's accusing anyone of racism.
but that it's incumbent upon all of us to look into our own self, you know, and try to listen to other people who are different than we are, and try to put us in their shoes, and just recognize that unconsciously we may be carrying certain stereotypes that we're not aware of. So I think the goal is to just have an open dialogue. And even though it makes some people feel uncomfortable, I think the more we discuss it without shaming or, you know, pointing fingers, the more jurors are going to feel comfortable. Not only recognize their own bias, but also just have a different perspective on the case, the people involved in the case.
Jane?
Hi, so I'm a public defender from Alameda County, and I actually do training on race in the courtroom. And I wanted to just touch on the answer to that question because it's really hard. I mean, that's the bottom line. But it requires a lot of, what I always say when I train people at the very beginning is the first thing is to know thyself and do our own learning or unlearning. Because if we're not comfortable kind of talking about it just out in, not like necessarily when we're like enraged about something, but just in general, then it's really hard to have a conversation with other people. But beyond that, just the technical things, it's just a lot of strategy, really thinking about your case and what are the things that are going to come up. I had a recent self-defense case. My client was a Black man, and I knew that I certainly believe that Black men are probably not entitled to self-defense in this country. And really trying to talk about and think about what kinds of things were going to come up for the jurors. And then how could I kind of equate those to common day experiences and pull it down to levels that we can all relate to. And then getting the judge to talk about the jury instructions before I got up and spoke. And I'm particularly sensitive because as a Black woman, I am going to be probably deemed as playing the race card. And so getting the judge on board right away, early on, to understand what I know the issues are going to be in the case so the judge doesn't shut me down. Then starting to engage the jury, understanding my case, where I'm going, and just really figuring out strategically how to talk about it.
Thank you.
Yeah.
But it's hard. Having said all that.
I think we have to end now, but I want to be sure we thank these incredible people for
Professor Mia Bird is sick and was not able to be here to moderate. We're sad to miss her, but I am stepping in and hopefully we'll be able to fill shoes in some way. So welcome to the data panel. We've got 4 great speakers for this portion of the afternoon. Dr. Deepak Premkumar is a research fellow at PPIC, the Public Policy Institute of California. Through the lens and tools of an economist, he aims to provide an empirical guide for understanding questions and trade-offs related to the criminal justice system. Some of his work has explored the social costs of policing, investigated racial disparities in police interactions, and examined how the COVID-19 pandemic and its associated policies affected criminal justice outcomes. His research has been featured in numerous media outlets, such as The Washington Post, and has been regularly cited in policy discourse, both by local and state agencies in California and in legislation. He received his PhD in applied economics from UC Berkeley in 2020. Next, Professor David Ball works primarily in the field of criminal justice, writing and teaching in the areas of criminal law, criminal procedure, sentencing, and corrections. He has published articles in the Columbia Law Review, the NYU Law Review, the Yale Law and Policy Review, and the Annals of the American Academy of Political and Social Science. He is the co-author with Michelle Oberman of an open source criminal law casebook and has been co-chair of the Corrections Committee of the American Bar Association's Criminal Justice Section for more than a decade. He has also served as the chair of the Public Safety Working Group for Lieutenant Governor Gavin Newsom's Blue Ribbon Commission on Marijuana Law and Policy, and was a member of the Santa Clara County Alternatives to Incarceration Task Force. Dr. Elsa Chen is a professor and the department chair of political science at Santa Clara University. Her current research examines policy reforms associated with the de-escalation of mass incarceration and prisoner reintegration into society, including automated criminal record expungement. Dr. Chen co-edited Beyond Recidivism, New Approaches to Research on Prisoner Reentry and Reintegration, and her work has appeared in numerous academic journals. She was part of the National Academies of Science, Engineering, and Medicine Consensus Committee that wrote The Limits of Recidivism, Measuring Success After Prison in 2022. Dr. Chen has served on the executive board of the American Society of Criminology, chaired ASC's Division on People of Color and Crime, and served on the U.S. Department of Justice Office of Justice Programs Science Advisory Board and the ASC Policy Committee. And Elizabeth Lashley-Haynes is a Deputy Public Defender at the Los Angeles County Office of the Public Defender, where she's worked for over 20 years. She leads her office's Racial Justice Unit and has developed and currently runs a statewide Public Defender Racial Justice Act working group with representatives from 23 counties across California. She graduated from Syracuse University with degrees in sociology and African American studies and spent time in the southern region of Africa studying colonialism and emancipation. Elizabeth graduated from Case Western Reserve University School of Law, where she focused on racial disparities in the legal system and mass incarceration. All right.
Well, I'm thrilled to be here today to talk a little bit about what we can say, what the research contains about race and policing. And I'll talk a little bit about my own research, but I'll also try and draw in on why it's important and relevant when considering questions around the Racial Justice Act. Now, as Lisa Romo talked about in the start of the day, the impetus for the Racial Justice Act was not necessarily implemented as a tool to blame criminal justice actors. It was created as a tool, as a remedy really, for inequitable treatment under the law by race. And when we look at the A3 and A4 claims, which are the claims that I'm focused on as a researcher and an economist, I'm specifically highlighting that these are racial disparity claims. And that subtle difference between racial bias and racial disparities is an important one, especially when you start talking to experts. The A3 and A4 claims from a plain text reading, which I've put up here, have no mention of bias. Bias implies intent, conscious or otherwise, and it implies that you need to provide some evidence as to being able to prove that. Whereas disparities just highlight inequitable treatment under the law, and in this case, racially. And because these A3 and A4 claims require no determination of what is causing the disparity, we really should be focusing on identifying racial disparities in both charging, conviction, and sentencing for those individuals that are similarly situated, that have engaged in similar conduct. Now, a big part of that is looking a little bit more upstream. Like a big part where a lot of the experts may start is looking at charging decisions. But before that, we know that the criminal justice system has this whole aspect of policing, and that creates racial inequities in themselves. And when analyzing whether people are similarly situated and taking into account various factors that are important in charging and sentencing decisions, it is highly relevant to consider stop data. The last bullet point I put up there is another thing that's contained within the text of the Racial Justice Act, which means that as a court considers the totality of the evidence, it's important to consider whether systemic racial bias, racial profiling, or racially biased policing or prosecution contributed in differences. So when we look at similarly situated circumstances and we make comparisons based on someone's conviction history or arrest history, some things that perhaps the defense side could bring up is whether biased policing could have contributed to these factors. Now, my first slide is on the Racial Justice Act, then my second slide has to be about data. Now, I often get made fun of as a researcher because every single presentation ends with, we need more data. But if you look at the fact that what we're trying to understand are systemic differences across race among a variety of outcomes across the criminal justice space, data is necessary for that. And a decade ago in California was one of the least transparent states when it came to criminal justice data, particularly when it came to policing. And that has radically changed in the decade that's transpired since, particularly in the space of policing. There's a lot of work to be done in the prosecutorial space. And a big part of that is in 2015, California passed the Racial and Identity Profiling Act. And I know a handful of practitioners in the room today have used some of this RIPA data or police stop data in their RJA motions. Now, that law created the most comprehensive data set for any state in the entire country. And it allows us to evaluate these questions of how individuals in a variety of different circumstances were treated. And we're able to control for all these contextual factors to identify, were they treated differently because of their race? So again, the RIPA data contains the most detailed set of data on police stops. A stop is defined as any detention of a person by a police officer or any action in which an officer results in a search of a person or a vehicle. Now, we at PIC have conducted 2 research reports using RIPA data. We used RIPA data from 2019, which contained 4 million stops of the state's 15 largest agencies to evaluate racial disparities in law enforcement interactions across a variety of outcomes. And then the second report focused on traffic stops. And I know for a lot of you in the room, statewide analyses aren't necessarily the level of proof necessary for some of these RJA claims. So in the technical appendix in one of our reports, we actually have all of the descriptive statistics broken down by law enforcement agency that hopefully can be helpful as you try and evaluate whether there are racial differences across stops, searches, discovery, enforcement, etc. So the RIPA data contain information on perceived demographic information, such as the race, age, mental health status, etc., of the person being stopped. But importantly, it also contains valuable contextual information related to the police stop, the reason for the stop, whether it was a call for service, whether there was a search taken, if there was discovery of a crime or contraband in the search process, and how that stop was enforced. And we're able to use all that information to get an understanding of how individuals are stopped by police and how eventually they get to the side of where a prosecutor sees them in potential charging decisions. And we've used this RIPA data to inform conversations both locally and across the state around policing and race. And later I'll talk about how we've used it in San Francisco, for example, as the San Francisco Police Commission was considering limiting low-level traffic violations. Now, an important thing to address when I present my results in a little bit is that disparities may reflect context or it may reflect bias. For example, if I were to show you racial disparities in police use of force, important contextual information may be differences in whether the individual stopped had a weapon on them. And thankfully, because the RIPA data is so detailed, we are able to control for a variety of these factors, getting closer to what we consider like the similarly situated under similar conduct. As we make these controls, we're getting closer and closer to what we consider an estimate of bias, at least a lower bound estimate. But as we discuss that, one important note from the research literature is that economists, other social scientists have examined racial bias across a variety of occupations and settings, and they found that it's relatively pervasive and it exists in the criminal justice system, both at the policing end, but also prosecuting and judges. So it wouldn't be super surprising or outside the literature's norms to find something. So our specific analysis is this apples to apples comparison, or what we consider something akin to a similar conduct in similarly situated individuals, we're taking this RIPA data, we see differences, for example, in searches, which I'll present soon, but then we're able to control for a variety of demographic factors. What was the reason for stop, and where was the stop taking place, and by what law enforcement agency? And basically, by doing that, we're able to compare, like in our ideal thought experiment, whether a black and white individual in the same city, stopped by the same law enforcement agency, both of whom didn't have a weapon on them, but the police stopped them for the same reason, were they treated differently solely based on race as the underlying factor after controlling for everything else? Now, this is a far more restrictive approach that's necessary for an RJA claim. We did it for a research report unrelated to the RJA, but hopefully it provides a baseline understanding of what could a valuable methodology be. And again, we're going to present information on a statewide analysis comparing black and white individuals, but the research report itself has the 8 race groups included in the RIPA data. Now, on the left-hand side, the far left-hand side, we have presented the observed differences in the search gap between black and white individuals. So on average, black Californians who are stopped are searched 20% of the time, while white Californians are stopped 8% of the time. That results in this 12 percentage point difference right here. Yeah. Now, that's about 2.5 times more likely to be searched. But there could be searched for a variety of different reasons. So after we control for perceived demographic characteristics such as age, gender, mental health status, etc., we can see that the search disparity starts going down. And the same is true if we start adding controls on top of demographic ones, including the reason for stop and the law enforcement agency and the city in which the stop takes place. This is all to show that contextual factors do play a role in explaining racial disparities, but this resulting bar right here is after controlling for all of these various variables, we're still able to say that there is a statistically significant difference between black and white individuals in California in how often they're stopped. Black individuals are still stopped 1.5 times more than white individuals after controlling for all of these things. And this is important when we have these conversations about the purpose of the Racial Justice Act. If we're think of it as like a team effort and everyone interested in reducing racial disparities, this is a place where when we've had conversations with law enforcement, they're like, oh, this is helpful that we're able to adjust for all of these things. And what could potential policies be to reduce it? So looking at search disparities is one thing. So we did the same analysis looking at, all right, these people are stopped, but what do you find in this racial gap? And you actually find in the raw data, which is again shown in the orange, that black individuals have evidence of a crime or contraband on them less than white individuals. And when you take into account the similarly situated under similar conduct, or all of these various controls for, again, the demographics, the reason for stop, the stated reason by the police officer as the basis for search, and the law enforcement agency, we see this gap actually grows. That similarly situated black Californians are 10% less likely to have evidence of contraband or evidence of a crime. Now, so the first report that we released related to this highlighted racial disparities in stops, searches, and experiences. And as we highlighted initially, black Californians are 2.5 times more likely to be searched, but they're less likely to have evidence of contraband. And the stop context explains some of these factors, but we still see statistically significant and notable disparities after accounting for such factors. And how does this play into the Racial Justice Act? These things are a little farther upstream than charging, but it does play an integral role for what the prosecutors have. And if the basis of the Racial Justice Act is inequitable treatment under the law, we can see that this has been happening far before they get to the point in the charging decision. However, even if we were to just look at arrests, using our stop data, which the RIPA data contains, It shows that Black people are 14% more likely to be arrested with the most restrictive set of controls that I described. And that's important because in the Racial Justice Act, it says you can consider the totality of evidence that perhaps like a past arrest or an outstanding warrant may be associated with racially biased policing or racially biased prosecution. And we're controlling for all of that. So this is the most conservative estimate, this 14%. Our report also found that traffic stops were a key driver in these disparities, and that traffic stops, particularly of police departments. And I've noticed that some of the practitioners in this room have used RIPA data and particularly traffic stop disparities to highlight for their RJA motions. So as someone that does research in public policy context, we were looking at traffic stops as a potential way to come up with alternative enforcement mechanisms, particularly since 1/3 of them are for equipment and non-moving violations, which suggests that they're less integral to traffic safety. And about 15% of serious use of force incidents occur during these traffic stops. So this is part of the conversation we brought to, for example, the SF Police Commission when we were highlighting that in our report. Now, we find that there are traffic stops where there is no enforcement, and if a search took place, there was no discovery of any evidence or contraband. And we tried to look at the racial disparities in what we call no enforcement, no discovery stops. This is about 6% of traffic stops, which means that's about over 200,000 of them, which means thousands of law enforcement hours have been gone into these no enforcement, no discovery traffic stops. And we find that they're disproportionately stopping Black individuals. And these disparities are higher when we think about how intrusive they are. So when individuals are asked to step outside of the vehicle, when they're curbside or vehicle detention, when they're handcuffed, when it involves the use of an officer's weapon. And this is all to show that these racial disparities occur even in cases where an individual is let go from a stop without even a warning. Now, we also did some tests of racial bias, but for time, I'm not going to go over them. We did find racial bias, but again, that is a higher standard necessary than one in the Racial Justice Act, but I'm putting it in here because my slides contain it. You can always go back and look at it a little bit more closely. One of the big consequences of this, if we think about alternative enforcement mechanisms, is confiscation of firearms, which is a big public safety concern if we limit the amount of traffic stops. We actually found that confiscation of firearms is not actually that present in some of these traffic stops, and that some of the searches that were being done during these traffic stops, particularly consent searches, which are disproportionately applied to younger individuals, results in a smaller firearm confiscation share, something that might be useful when you look at who's being searched and why. Now, again, the research literature does confirm a lot of what we found in the California context. This isn't new things, but it is important to look at different settings. I'm just providing this here. And finally, when looking at potential policy reforms of what we can do from this, we found that by presenting some of this information, the Racial Justice Act is one tool to remedy inequitable racial treatment. But if we want to reduce racial disparities across the criminal justice system, there are a wide range of policy solutions. And the Racial Justice Act is one that occurs after there has been a violation of this. So we were looking into potential policy reforms, and some cities have already limited stops for minor traffic violations and then chose to enforce traffic violations through mailing warnings or citations. California is now piloting has red light cameras and piloting automated speed cameras. But again, all of these require evaluating the unintended effects on public and traffic safety. But we look forward to using this research that we've built on for just identifying racial disparities throughout the criminal justice system and seeing how it applies to the California Racial Justice Act. Thank you.
So I really just want to first off thank Todd and all the folks at NCIP for all the work that's they put into this conference, and also all of the students. Although I think I'm sensing that many of you, like me, who are maybe closer to the grave than students are, wish there had been more coffee. So, but I'm really glad to be here. I'm really glad that there are so many practitioners here, and you're the folks I want to talk to. And actually, I've spoken to several of you already, and there are some common issues that come up. And the main point of my remarks is along the lines of what Professor Grosso already said, so I must be onto something. Definitely don't, if you disagree with me, it's not her fault, but if you agree with me, it's probably her fault. So, data is evidence, and lawyers are used to making arguments about what evidence means. Everyone is used to that, right? When I tell my son, who's a second semester high school senior, that if he doesn't clean up his room, I'm going to kill him, that's certainly consistent with an actual criminal threat or attempted murder, depending on how aggressive the local prosecutor is, or it's just a joke, right? But the point is that we all deal with narratives, and those narratives both fit the data. We just have to pick which one is the more likely explanation for what that utterance meant, right? So in statistics, that just means you use different models for fitting the data, but it's the kind of thing that you do all the time. It just has numbers attached to them. And so there's some data issues I'm not going to discuss in this talk that you've already heard about, about gathering data, about how accurate it is this all the data, et cetera. But there is a general consensus, as we've just heard from social science and from the legislative findings of the RJA itself, that there are racial disparities in the criminal legal system, right? And the issue is once, per the structure of the RJA, once there has been proven to be a substantial difference, right? The issue is what those mean, whether or not the prosecution can provide race-neutral reasons for what this disparity is. Okay, so let me see if I can, I'll do it this way. Nope, Law School of Silicon Valley moment. Sorry about that, everybody, but that's part of our brand. Okay, so these are all quotes about data, right? And what data means, I'm a data singular person, not a data plural person, right? So what data means is a question of judgment, right? This is true of science. This is true every time you go to the doctor. I have a rash. What's the most likely cause of that? It could be a variety of things, but this is more likely than that based on what I know. There can be more than one reason behind it, so you pick the best one, right? So the problem is that most people go to law school to avoid numbers. And we run into this problem that someone has coined quantification, right? You get to numbers and you feel like, okay, that's it. I can't argue with that. I can't talk back to the numbers. I'm scared of them. But the numbers are just evidence. You still can make arguments about what numbers mean. And so what I want to focus on here really are three things. First, what data tells us depends on what we ask of it. All data are theory-laden. The numbers don't speak for themselves. And second, I'm going to present two competing explanatory models, race-neutral and race-responsive, that could both explain the same data, particularly about conviction history, which is what I'm writing about, but I'm not going to talk about as much in this talk. So a race-neutral one would say that observed disparities are due to offense characteristics or offender characteristics, so something about either the conviction history of the person or about how they did what they did. And a race-responsive explanation would be that the system treats people of different races differently. Both theories fit the data. And the question about which one we believe ultimately depends on whether the assumption behind those models, assumptions which require us to apply our theory and background knowledge about how the world works, are persuasive. I'm going to present two complications of these models as well. One says the numbers are a combination of offender characteristics and system treatment. So it's not just that, say, conviction history is different across racial groups, but that conviction history itself is treated differently as well. And the second one is really to surface the fact that there's a history of racial modeling that we need to rebuke that was expressly racist. In the early days of statistical analysis, statistics departments literally grew from eugenics departments. Eugenics departments preceded statistical departments, and race was the causal explanation for crime, particularly when it came to people of African descent. Black people were seen as racially degenerate, and that's why they caused crimes. It's extremely painful to say that, but that is what was said by many people who went to Stanford, many of whom had elementary schools named after them that are now renamed, like Lewis Terman and I forget what Jordan's first name is, right? So for a host of reasons, and I think, among them that the RJA's point is for us to really eradicate racism in the system. I think it's crucial for us to point this out and to require that we expressly disavow it. So finally, the third thing I'm going to point out is that some best practices for dealing with conviction history, because that is a common explanation for different outcomes that are presented as race-neutral reasons. There's no one model again, but the main best practice is to say this is how we explain what real-world phenomena are appearing in the data. But that is about your expertise as a practitioner, and I'm skeptical, of course, that conviction history is race-neutral, and I'm sure lots of people could point out why they also are skeptical of that. So data analysis, like all science, requires models. So bad news, lawyers, there's no such thing as the test or the way of analyzing data. There's no simple recipe that one size fits all. And data analysis works best if you have a hypothesis first. It's like science. I think gravity would do this, so let's do this kind of test. If you don't have a model or an underlying theory, you don't know what is relevant or what to look for. And so this is best expressed in a study by Silbertson et al. Like, I normally am not into the et al. Thing, but there are literally 62 other people listed in this thing, because what happened here is they gave the same set of data to 29 teams of researchers with a very clearly defined research question about soccer. Is darker skin color of a player associated with an increased likelihood of getting a red card, which is expulsion from the game for those of you who do not watch it? So there's a clear independent variable, skin color, and a clear dependent variable, getting a red card. We all know when the red card happens, right? Unlike crime, we actually can observe the red card being given. And the skin color was done in an independent test, rank these people on basis of their skin color. And so the issue here was how you isolate the other factors that might also be responsible for causing someone to get a red card. What are non-skin color reasons for red cards? You want to include the most important variables that might be correlated, but you just can't include everything. So including all variables reduces the explanatory value of any one. It can obscure real relationships or generate misleading relationships. So in this example, right, everybody got the same data, and the 29 research teams used 21 distinct combinations of variables besides skin color. Those are called covariates, right? So just another word for variables that also change and might explain the issuance of red cards. Everyone used one variable, which was the number of games under a given referee. But other than that, just one other variable was used in more than half of the analyses, and 3 were used in just one analysis. So these are things like a player's height, a player's weight, the referee's country of origin, etc. And there were different outcomes based on these different models. Some teams found no relationship between skin color and red cards. Some found different magnitudes of the relationship, or as we students of the RJA might say, significant differences. But the point is that there were many ways of looking at the data, and how you looked at it changed the results you got. So you have to go back and look at these choices and figure out which one is most persuasive and why. Now, this is an idealized situation. We don't have that in any RJA case. We don't all have the same data. There's a clear outcome. Again, red cards, right? They all agreed on the outcomes, not is there racism or are there race-neutral reasons? Because if you were looking at that, you might say player pay or booing or racist chants or fouls or yellow cards or something like that. At the same time, it's also useful as a model for crime data because there's a single set of rules in soccer, and the decision about whether to give a red card is discretionary. The same way we have a uniform penal code in California and discretion about whether to arrest, what to arrest for, what to charge, what to sentence, et cetera, et cetera. And I want to emphasize all of the 29 teams were professionals. They disagreed. We're lawyers. We're also used to disagreeing. The issue here is just whose choices were more justifiable, not who made choices, because everyone did and everyone does. The interpretation is always the key, not the data itself. It's what you do with the data that gives it meaning, and you're always doing something. So how will we model criminal legal system data? We know from the paper I co-wrote with Bill Sundstrom and Colleen Chen, I'll have a reference to that later on, as well as many others, that Blackness is associated with criminal legal system involvement. So I'll focus on Blackness. Hispanic is not a race, except in California. God love this state, right? And so the two models that I want to discuss initially are race responsive and race neutral, which I'll call in this section crime or criminal history responsive. So race responsive says, yeah, it's the response is to Blackness that drives disparities in system treatment. The race neutral model would say Black people and white people commit different crimes at different rates and or that they're different along some offense characteristics. Now, a foundational problem, of course, is that crimes themselves are judgments. Even homicide, is this a justifiable self-defense claim, mistaken self-defense, first-degree murder, with or without special circumstances, second-degree murder, manslaughter, et cetera, et cetera. These are all contested ways of explaining the same kind of event, which is where someone caused someone else's death. We argue about this in the law. Which is the best fit? What's the best charge for what happened and why? So if we say Black people have more arrests, therefore they commit more crimes, that is a choice. That is an explanation, right? The numbers of arrests are probably real, but the interpretation, this causal story, that they correspond to actual crime is a choice. And I say the number of arrests are probably real because we don't know everything about crime. We don't actually even clear all homicides and clearance, even as measured by an arrest in a given case, right, varies in the 75 biggest municipal districts, between like 50 and maybe 75, 80%. And there are two complications that I want to talk about. So first, do we treat offense differences the same? So Deva Pager did a study, and I'm looking at this because it's a little bit easier to get your head around, but there's a criminal example in a second. She did a study that looked at callbacks for employment interviews where she isolated the effect of a criminal record. Okay, so time in prison hurts callback rates. If you have a record, at least in Milwaukee where the study was done, you get called back less often. But if you're a Black person without a criminal record, you get called back less than a white person with a record, and records decrease callbacks for Black people by 2/3 and only 50% for white applicants. So if you were just to look at criminal record as an explanation, you would be missing something. Just as if you were only looking at race, you would also be missing something. So this says it's not just race responsive or crime criminal history responsive, but both. And Sherrod Thaxton has done this in the death penalty context using all the cases in Georgia. These are crimes with white victims, and the circumstances of those crimes are generally different from crimes with Black victims. But it's also true that circumstances themselves are treated differently depending on the race of the victim. Even opposite sign effects. So Sherrod, well, I know I'm Dr. Thaxton, Professor Thaxton, whatever, the defendant's marital status, military service, firearm usage, among other things, literally made it more likely or less likely, depending on the race of the victim, about whether or not you were going to get charged with a death sentence. So this is not just a one-way street, either or. It's once there is a difference, how is that treated also depends in some ways on race. And then finally, there's the implicit model, race, particularly Blackness, as the cause of crime. Note that obviously, Blackness is not a scientific term, but this is a book that I highly recommend to everybody by Khalil Gibran Muhammad. Around the turn of the 20th century, foreign-born white people had crime rates comparable to native-born Black people, but social causes were seen as the cause of foreign-born white crime, while innate racial characteristics were seen as the cause of Black crime. We've mostly moved on from this, but not entirely, right? Charles Murray is a prominent example, Heather McDonald. But if the model is that Black people commit more crime, we have to ask what the assumptions are behind this. Right? What is the biological foundation of race to begin with? It makes phrenology look like really good science. What's the causal factor of, say, melanin with crime? Like, how does what we know about the skin cancer protective properties of melanin, skin pigmentation, also fit in with models of human behavior? Right? So what's crime protective about less pigmentation? If race causes crime, how do rates of offending normalize across contexts? So do people of Chinese descent, for example, have similar crime involvement in Taiwan, the People's Republic of China, Malaysia, and San Francisco, among other places? Spoiler alert, no. And so I haven't seen any evidence supporting this. So what to do moving forward, right? And so I'm going to really just summarize here. I just want to make sure that anytime someone is saying the numbers say this, that people are explicit about their theory or model of criminality. So you should demand that the people who stand up and say, we know this because of arrests, right? You really want to say to them, why are you saying that? Because that's a choice. It's not just a choice when you say it isn't race neutral. So put another way, we live in the world. These numbers come from the world, and their collection is a human activity, and their interpretation is too. And just the last thing I'll say is, so this is our study, right? Our study shows that wobblers are race responsive. Wobblers, for those of you who don't know, are crimes that can be charged as a felony or a misdemeanor. They're the same penal code section, right? And if you look at the black-white comparison, subject to even these sorts of controls, right? So felony prior, no felony prior, or even first offense. The long bars are the 95% confidence interval, for the 5 most commonly charged wobblers in LA County, that you're always charged more as a Black person. That's not even accounting for the fact that arrests are much more likely, police presence is much more likely in a Black neighborhood. But even choosing to start the clock once a wobbler is charged, it's charged with a felony more often for Black people than not, right? So that's really, I think, because of time, that's where I'm going to stop. So thanks very much for that. There's a lot more in this article. And again, if the numbers did speak for themselves, this would be a 1-page article with this picture. It's like 75 pages because we go through why we think this is a good rationale and why this is a good test and what we think the numbers mean and don't mean. So don't settle for anything less, when people's liberty is at stake. Thanks.
I just want to start really briefly because I'm just feeling this way. I just want to start with some gratitudes. I was thinking that it reminded me of a really gnarly murder trial I was in maybe a decade or so ago, and my co-counsel had us either start or end each day with gratitudes. And some of those days, by the end of the day, I may or may not have been sobbing as she made me say gratitudes, but I thought it was a good thing. So as I was sitting here and listening to the previous panels, I just thought I'm super grateful to be here today. If you would have told me when I started as a public defender that there would be a Racial Justice Act, I wouldn't have believed it. If you told me that I would be here today discussing all of this with all of us coming together, I wouldn't have believed it. So I'm grateful to be here. I'm grateful for Santa Clara for hosting this, all the organizations that supported this. I'm grateful for the Racial Justice Act. It was a long time coming, and California, really is groundbreaking in this regard. I'm grateful for Professor Chen and these things that I feel I've dragged her into. And I'm also grateful to be from LA County, where we have prosecutors who are here and who care about racial justice and who I think are partners where we are all committed to one common goal, which is reducing bias in our justice system. So I'm feeling just a great deal of gratitude. Sorry, that wasn't part of the plan. So I have a little bit of imposter syndrome being on this particular panel. So, they're all incredible data people, and I'm just like a scrappy attorney. So, and I don't hold myself out there to be like an expert on this is how, I'm going to teach you all how to bring a wonderful data claim. That's not what I'm going to do. I'm going to talk to you about sort of my experience of fumbling through the Racial Justice Act with data-based claims, and just some of the things that I focus on, some of the things that I have picked up along the way. This is kind of a map of what we're going to talk about. And we're also going to discuss sort of our intersection, right? And how we have, I would say, fumbled through a case and issue together. So the first thing, I wanted to cover was finding the right case. Everyone has covered this pretty adequately today, which is you really have to focus on a case where you can set up a similarly situated situation. So I've looked at cases, attorneys have brought cases to me, and I know that I will, they are only one apple, right? It's a case where it is just such a crazy fact pattern. There's just way too much going on. I know that I will never be able to find other similarly situated cases to do the comparison. So for me, that's not the right kind of case, right? And it's unfortunate because the attorneys will come to me, we'll talk about it, and I'm like, yes, the fact that he got 185 years is outrageous, right? It was probably impacted by his race. We all know that, right? But it's such a unique type of case that I know I'm not going to be able to do that apples to apples comparison, and it would end up like this. I would only be comparing apples to oranges. I don't want to belabor this one too much because there's already been a bunch of wonderful people who have covered sort of how and where we obtain the data on the earlier panels. But obviously, through the 745D, luckily the statute, it was really baked in there that we can bring a D motion and we can litigate it in the courts. We can get the judges to order that data to be turned over if we need to. CPRA is a wonderful tool, and think about all the various places where you can obtain that data. CDCR, the DA's office, DOJ, et cetera, it goes on and on. You can use your internal case management system. Obviously with caution, you have to have conversations with your internal office, structure and management and figure out if, when, where, and how you can use that. But I believe you can, depending on what your system captures and how reliable and all of that. So in LA County, in our office, we have an incredibly reliable system because all it does is mirror the court system. So whatever happens in court gets funneled into our case management system. Don't overlook and don't sleep on open data portals. I have lots of conversations with attorneys and consults where I say, well, have you checked your city or your county's open data portal? And they haven't. So things are changing, In LA County, there's a city data open portal. There's a county data open portal. So lots of places have these now, especially with RIPA, which you guys are hearing a lot about. A lot of police agencies, the LASD, the Sheriff's Department in Los Angeles just put out their website, which has an incredible amount of transparent information. So do not overlook what may be just publicly available on the internet. It's incredible nowadays. And also, you really have to comb all of the amazing websites that are being hosted by various organizations, public policy institutes, nonprofits, things like that. I listed just a few here, but DPIC, the Death Penalty Information Center, Burns Institute has an incredible juvenile interactive portal. There's so many different ways you can obtain the data. Okay. Yeah.
Cover this one.
Yes. Okay. Sorry. Yes. I think I don't want to repeat things that have been said all day. Writ the issues if they're a problem, litigate the denials of CPRA. ACLU has done some amazing work in that area. When in doubt, try again. Just because you got to know the first time on data doesn't mean you can't go back and relitigate it. I would just say just because you got one door closed, just turn the other way and find a new door to open. A lot of these places and these things, you have a right to this information. The public has a right to this information. Our clients have a right to it. So keep going. I think this is probably the most important slide and the most important topic for me. If you're making a database claim, don't just start with the numbers. Start with the historical context of what your issue is, okay? So I don't like, I mean, we're talking about such a heavy topic here, right? I don't like just looking at numbers. You have to know the history of the racism and what is going on with that particular issue, because these are all so different. You've got to really know and put it all in context. And we've talked about narratives before, right? It's not enough just to throw some numbers up there. You really have to contextualize what is going on. And you need to understand it before you get those numbers. And then you need to be able to go into court and tell that narrative of, it's not enough to just, in my opinion, it's not enough to just say Black people are disproportionately stopped. Why? Why? Where did that start? You're going to have to explain this to a judge who might not be receptive. Okay. So you just throw some numbers up there. It's easy to discount numbers. Okay. But if you go in there and you explain, Judge, do you know the history of in California? Do you know that this law existed about Latino people and this and that, and they were disproportionately displaced from here? And, you have to be able to put this in context. I mean, I filed a RJA in a case, and I did this deep dive into the history of Culver City. Culver City was a planned community for white people. It literally was advertised, come live here. It's a nice white town. I found an ad that said that when it started. So I put that whole context in. And when I walked into court, the district attorney who was there, not the RJA DAs, but the one who was there, had read my motion. And as soon as I walked into court, she's like, I knew Culver City was racist. I knew it, and it was just, it was great. I really did a deep dive, and it hits home to what a lot of people already know. And now we're able to, now we're at a point where we can start really digging into what's going on here. So how do you find an expert? Evan really covered this earlier, and I was so happy, his answer was sort of exactly what I was going to cover here, which is, and he and I have the same approach. So I wanted to litigate third strikes and, the sort of obvious racial disparities in third strike. And so what did I do? I started doing the deep dive, right? I went back and I read the third strike law. I read the legislation that went on behind that, right? And then I started researching all the social science research and looking for who's done what and what is already out there. And I found all of these, and they all seem to be done by this professor named Elsa Chen. And so I was like, I need Elsa Chen. And so I maybe have stalked her a little bit in the beginning. I just could tell after I had read all this that she was the person who had already done all the research that I was interested in.
So I'll tell you a little bit about my research, and then I'll show you some of the data in a little more detail in a minute. But my prior research, I work at the intersection of political science, public policy, criminology, and I do a lot of qualitative and quantitative work. And my prior research has looked at sentencing outcomes for individuals of different races, ethnicities, and ages, while controlling for legally relevant variables such as the current conviction offense and the number of serious and violent priors. And that practice really feeds very well into looking for similarly situated individuals, right? You're controlling for what did they do this time, how many prior serious and violent offenses do they have. So they're kind of more like apples to apples than apples to oranges. And in my work, I found racial disparities in the application of three strike sentences under the original version of the law in California, with Black individuals more likely to receive third strike sentences than people of any other race. And I've also found that the Black-white gap in sentencing outcomes has been particularly large for the lowest level eligible offenses, also known as wobblers, and I'm grateful to Professor Ball for explaining that already too, in California. And that was like back in 2008. I started finding these kinds of outcomes. I've also looked at how demographic and political characteristics in local jurisdictions influence sentencing outcomes, including in third strike sentencing. And then I've done some qualitative work looking at the characteristics of courtroom work groups that have influenced the implementation of Proposition 36 to reform three strikes. And that involved talking to a lot of folks who were working in the counties on Proposition 36. And consistent throughout a lot of the work that I found is the more discretion there is, the more disparity there is. And, again, we don't have to talk about bias. We don't have to talk about racism. As Deepak pointed out, we only have to talk about disparity, so different outcomes. You want to do this one?
No, you could do it.
I'm going to skip this one then. So my next slide is
we were there. Okay.
basically about why social scientists and lawyers should hang out more. And it reminded me, and this is now I'm dating myself, it reminded me of this commercial. I hope I can get it to go. This
is always
yes.
Everybody.
Oh, it doesn't want to go. Okay. Oh, I wanted to do something funny before I hit you with a whole bunch of data. Okay. This is, I have to click on this side. This is the goofiest commercial.
Peanut butter. Hey, you put your chocolate in my peanut butter.
Peanut butter in my chocolate.
Delicious.
Two great tastes that taste great together. Reese's Peanut Butter Cups. Real milk chocolate delicious peanut butter.
Okay, so that's us. That's literally Elizabeth and me. I'm the dork who carries a tub of peanut butter while like jamming to my tunes walking down the street. Because I'm a social scientist and we're just kind of awkward like that. But, let's talk a little bit about why social scientists and lawyers should be friends. We have totally complementary skill sets. So lawyers have in-depth knowledge of the law and procedure and proper terminology. You all have just been kicking around all these terms. I have no idea what those terms are. I would, if I tried to use them, it would be like me trying to use Gen Z terminology around my kids. It's cringe. Is that the right word? You have the right terminology. You know what to do in the courtroom. You know the facts of the case better than we do, right? You have great minds that can create great legal strategies, and you're really good at storytelling. And we have knowledge of the literature, the body of expert knowledge, not just our own knowledge, but everybody else's knowledge, about disparities in certain types of outcomes. We know what we have found and also what other scholars have found, because that's what we have to do right at the beginning of every article that we publish. We have the ability to generate statistical evidence of disparities at an aggregate level. So, for example, statewide or in a specific county, if we have access to data from a specific county, or for all cases handled by a particular office or court during a particular time period, if we can get our grubby mitts on that kind of data. And we also, shout out to qualitative researchers, we also sometimes have valuable findings from qualitative research that can be very useful to you in court, right? Or if we don't have that knowledge, we have friends who can help if we can. So, I can always say, this is beyond the scope of my expertise, but let me introduce you to Professor so-and-so who has done 10 studies on this topic. We may rely on you for access to the data. So in all the ways that Elizabeth described, you can do public records requests. We could too, I guess, to CDCR or discovery motions. You can try to get internal data that might be useful to us. Sometimes it's very difficult for scholars from outside to get access to information from the courts or from DAs or from public defenders' offices. So you can help us that way, and we can help you figure out exactly what data you should be asking for. Prepare a declaration to include in your discovery motion. Am I using these terms properly? Yes. I have no idea, right? We can help you to negotiate with entities like CDCR to explain what we need and why. We've been doing this for a couple weeks now. CDCR
or months.
Months. I've been doing it for years, but when they give us something, it's not quite clear what that is. I can be there to sort of explain what we actually need, and you can help us apply our research skills and our knowledge to real cases that are tangible and meaningful and important and impactful. All these years, 20, 25 years, I've been thinking about racial and ethnic disparities. I found evidence and I'm just like, oh, this is terrible. And then all of a sudden RJA comes along and it's like, oh, we can do something about this. I'm excited to be able to apply this knowledge that I've generated over all these years. And you can even,
right there?
well, one more thing.
Okay,
You can
yeah.
even give us real examples to share with our students, right, about why research on racial justice actually matters.
Right. I think that's just to go back to like how our case happened and how this is all playing out. So we had a third strike case, a man who is back on resentencing. We had tried to get him resentenced for years. I've talked about this before, people who are at Berkeley. It's 6 or 8 years we were trying to get this man resentenced on what was essentially a theft. Okay, that's where he got his 30 to life on his theft, right? Been in 26 years. And the judge was adamant about resentencing him to life again. Adamant for the 6 years we were litigating it. And we started filing the RJA motion. We started with the D motion. And I pretty much used all of Elsa's research. I cited it all. I attached it all in a very thick motion with everything Elsa had already done. And lo and behold, the judge resentenced him. We never litigated the RJA, right? Or we started litigating the demotion. We never got through it because all of a sudden the judge's mind was magically changed. And he cited in his order, which I've said before, that this had nothing to do with race. Even though he changed his mind after 6 years of being super adamant. And so, it was nice for Elsa to know that all this work she had been doing, literally going back to the 90s, now had a real impact. And we're continuing this work. We weren't done there because obviously there's more and more guys and some women who are still sitting in prison on third strike sentences. So even though that case resolved, Elsa and I have continued our work. And we are continuing to comb through gigantic data sets we have about third strikers in California.
So I'll just talk a little bit about some of the questions you might want to ask when you're thinking about trying to find some data to support your case. So one is what's the outcome in question? Are you trying to say that there were disparities in charges or in convictions or sentences? The data set needs to include people who could have gotten that outcome, including people who did and did not get that, because you're trying to show that, more people of whatever race you're looking at got that negative outcome than people who did not. So you can't just start with a data set of, I know all the Black people who got this particular charge. You have to look at the Black people who did, the non-Black people who did, the Black people who did not, and the non-Black people who did not. So this is kind of, very fundamental statistics. I'm sorry if this is kind of obvious, but I wasn't really sure how far I can go. But I mean, Catherine hit you with logistic, log odds outcomes and stuff earlier, so I feel like I'm pretty safe. Which racial and ethnic group is being discriminated against? You have to have members of that group and a comparison group. So comparison group, typically white people. What arguments will be used to claim that your defendant was not similarly situated compared to the people whose outcomes were less severe? So if you're saying, well, Black folks got more charges for this certain thing than white folks, what are the arguments that are going to be used against you? And can you include data on those legally relevant characteristics? Like what's the current charge? What's the prior record? Now I know, and David, I think we've talked about this a little bit, right? Prior record is not race neutral. It's not race neutral, but as Deepak showed, even if you control for prior record, you can still show disparities because the bias is that apparent. So, you just want to preemptively address all those arguments that that are going to come. And then it's sometimes useful to have other characteristics that may be associated with the outcome, like age. So let's say that, you know, young people or older people are most likely to get third strike sentences. Let's include age then and control for that. And then another question is, how many cases do you need? Because you may get a response that says, that is just too much data, too much work. I can't find that much. We can't provide that much data. It would be prohibitively challenging. And I see that somebody else who I'm working with on a RJA case is nodding, because that's the response that we got. So then you can try to say, let's look for a random sample. Let's get a subsample, but make sure it's random and large enough to conduct a statistical significance test. And I'm not going to tell you the specific number, because that depends on the data and also the tests that you need, but you can discuss those with your brand new best friend, the social scientist. So, you know, we have several examples, or I've run into several examples where public defenders or others have contacted me and said, hey, I've got this great data set, can we show something with it? And it doesn't have variation across one of these dimensions. Did the person get or not get the outcome? Is the person, you know, from the ethnic group or not the ethnic group, the racial group or not the ethnic group? You have to have at least that much variation to be able to show evidence of disparity. Do we have time, or are we about out?
No, we're good. I want you
We
to
good?
show these.
Okay. Are you sure?
Yes.
Okay. So
Quick,
I was
you
like,
gotta
can
see
I
it.
show some data? Are you sure I should do this? I mean, these are lawyers. But Elizabeth's like, what
Yes.
is like percentages? So here we go. This just is some quick and dirty data from a study that I had done a while ago, using two data sets from CDCR. And the two data sets included all individuals incarcerated in CDCR facilities on November 7th, 2012, the day before Proposition 36 was passed and implemented, and 4 years later in 2016. So the first data set had like 134,000 people in it. The second one had like 129,000 people in it. And what I did was I started by saying, in the whole prison population in November 2012, what was the composition of the whole prison population? 29.5% were Black. That's already kind of disproportionate if you consider that like 5 or 6% of the whole population in California is Black, right? But then you look at third strikers at that time before Prop 36 was passed, 46% of third strikers are Black. So what does that tell you? There seems to be a disproportionate number of African Americans who are serving sentences for third strikes, even above and beyond the disproportionate share that are in the prison population, which is way above and beyond their share of the population, right? And then what I did was I pulled out all the people, the subset of individuals who appeared to be eligible for resentencing under Proposition 36, so we could get the apples to apples. And these were people who had 2 or more serious or violent priors, and whose current conviction was not serious or violent. And it excluded people who had all these disqualifying priors. So, you know, the murderers and the kidnappers and things like that, right? So then it showed that 41% of all Black third strikers were eligible for Proposition 36. So slightly less overrepresented, actually, than among all third strikers, but still very overrepresented. And that 41%, that's 3.2% of all Black people in prison. So pretty substantial number. The rest of the numbers, if you I'm saying numbers that are not on the slide, so if you're like, my eyes are feeling bad. I'm just trying to show you how disproportionate the sentencing has been.
Now we might.
Yeah, so we're going to be out of time. But
There's more. If anybody wants to know more.
Yeah, the main thing I found was that, people got resentenced at kind of, similar proportions, Blacks and whites, which left the racial disparity intact. So a lot of people thought Prop 36 was going to reduce the disparities by a lot, but it actually didn't really. And that whites continued to be the most likely to be resentenced, and that the reduction in disproportionality was actually the least for Black people for the area where there's the most discretion, which is weapons possession, which is actually the one place where Proposition 36 expressly left discretion in the hands of prosecutors. So I can show you all kinds of interesting stuff, but this isn't really relevant to your specific case. Your best friend, the social scientist, will be able to show you all the great data that's specifically relevant to your specific case.
Thank you.
I really, love this idea, the partnership, the lawyers, the social scientists. I want to ask our data folks about finding the balance between the apples to apples requiring that similarly situated conduct and the issues of sample size. And how do we establish for a court this idea that we have to show a significant difference? Doesn't have to be statistically significant, but where do we balance these ideas of how we limit the data set to those people who have committed similar conduct but not lose our sample size big enough to do some analysis?
I mean, do we know that they've committed similar conduct? We only know what the system response is, right? And that, I think, is where we would start off. And that's why I think that it is important to say that there are these formerly explicit and now implicit, associations with folks where you can say, why would you assume that any of the system numbers are themselves racially, so that is, right, we don't observe crime, we observe the system's response to crime. And we are going to run into these problems of small ends, because you have to compare in the county itself, right? And so there, I think you could use sort of Bayesian priors. I'll leave it to you. I don't know, you can't really solve for the fact that there's not enough data to make a statistical case. Maybe we're back to Yick-Wo versus Hopkins, where it's like, well, every single person, who is white isn't charged, and every single person who is charged is Chinese. I say Chinese because you were not allowed to be a Chinese American at the time Yick-Wo versus Hopkins was decided almost 200 years ago, right? Then that's what we're back to, and it's clearly not what the RJA contemplates.
Yeah, I have not participated as a data expert for an RJA claim, but I guess if I were a practitioner soliciting the help of a social scientist, one thing I would go through with them is, one, standards of evidence. When we talk about statistically significant, like all of the figures I showed you in my analysis, it's a very different standard of evidence, much, much higher than necessary for what is described in the prima facie case or even some of these more ones. This is very highly certain. And that's as a researcher, what we're trying to garner. And that's partially why we try and use such rigorous methods. So just explaining to an expert, you're not necessarily trying to get statistical significance in the same case and then explain different evidentiary standards that the law uses is helpful, and then adjusting your methods to match that.
Elizabeth, can you speak to, as a practitioner working on these cases in courts, what are you seeing, or what do you think judges are going to be impacted by as seeing as significant disparities?
And that's a great question, and I think it really depends on the judge. I think it depends on their background, their understanding of the history, of their understanding of implicit bias. And I think that one of our jobs is to make it as simplified and as user-friendly as humanly possible, right? And I think, that you've been able to do that successfully in your case, right? You've been able to take things that, most eyes gloss over and make it, I think we need to make it applicable to the current way that we are functioning as a society, which is 30-second videos online, right? And
it needs to be super user friendly, super digestible for a judge that's maybe handling an incredibly heavy calendar, right? And more worried about getting this done efficiently. You know, efficiency over justice is one of the biggest problems in our system. So the more that we can condense it, make it simple, and I think they want to know that nobody's playing games with the data. So however much you can convince them that these numbers are valid, accurate, and make it digestible, you know, is the way to go.
So the Racial Justice Act provides individual relief to an individual client for a systemic problem. I see this as this crucial partnership with the data scientists, the social scientists, to help us develop the information of that bigger systemic problem. And we're sort of working backwards, right? Instead of identifying the issue and then figuring out who are the defendants out there for whom it applies, we're starting with an individual person and trying to get the data working that direction. And one of the great tools of the RJA is the 745D discovery motion, right? So we can do the statewide research and then use that statewide data analysis as a good cause to get the county specific work. So that that's one direction. But what are other thoughts about how we can harness this individual remedy for what is systemic?
We've talked about two different aspects, right? One of them is, I work in that next building over there in the Department of Political Science. And so I feel like policy can be an outcome, a longer range outcome from, this work that we do, trying to uncover systematic, aggregated disparities. Once we have certain cases that are landmark cases, we can also continue, just like people did with RJA, right? You created policy. If it's apparent enough to policymakers that there's really like systemic injustice going on, maybe we can continue to advocate for systemic change.
Yeah, I think discovery is actually probably the most, that's what I see as being the real, getting past Armstrong versus United States is that's the key, right? Is that you no longer have to prove why in order to find out why, right? And that oftentimes, as you were talking about in the last panel, there are these gross smoking guns that, all the Antioch police text messages, you cannot defend that, right? And the reason why I brought up, like the Khalil Gibran Muhammad stuff is like, that used to be explicit and now it's just sort of, it's cleaned up a little bit, right? But there's a lot of that that's still underlying it, this belief about racial criminality. And you're acutely familiar with that. And so people can say, no, we don't do that anymore. But if you get discovery, you might find out that, people are still expressing that kind of stuff. Or there are other ways of proving that, like, this doesn't happen by accident.
Chelsea, how are we on time?
Like 6 minutes?
Okay. So with those 6 minutes, why don't we open up to audience questions? Don't mention.
What?
Hi. So thanks so much for the terrific panel. My name is Matt Bardo. I'm working with Professors Dick McCleary, who's out there, and Mona Lynch at UC Irvine on the RGA initiative, where we're trying to develop the social science expert pool to serve in these RGA cases. And I just wanted to ask you a question because, you discussed small sample issues, statistical significance, and I just wanted to get your thoughts on something that we've been discussing a lot in our meetings, which is that when it comes to these RJA cases, terms like sample and statistical significance don't really apply because usually what you're working with is population data. What you get is all of the cases in a particular category for a set period of time. You don't get a set sample of those cases, you get all of the cases. So when you do a measure of racial disparity, what you have is not an estimate of the disparity, what you have is the measure of the disparity. And there's no associated standard error, there's no sense in which you can talk about statistical significance because you're not taking a sample and extrapolating to a population, you have the population, so you just have the measure. And of course you need to kind of qualify your statements about that, what you have as a measure of the racial disparity for the period of time in which you have complete data. But if you make those kind of qualifications, it seems like statistical significance just doesn't make sense. And so I'm just curious with the data folks, what your thoughts are on that argument, whether that's something that you've encountered before, what what your thoughts on it are.
I'll just say quickly, like Sharon Thaxton talks about that in his article. He's like, I have all of the Georgia death penalty cases, so I'm not going to present any of those. There are no population estimates. Like I have the population, and in the paper that I co-wrote with Professors Chen and Sundstrom, we talk a lot about how we looked at it. So that the slide was up, but it's called Proving Actionable Racial Disparity, something, and it's in the UC Law SF journal.
Yeah, so I read the paper and there are confidence intervals in there, and so that's based on a standard error, which I mean, if you have all the cases, is what is it?
Yeah, so that has to do with how Bill was sort of dealing with the data, but I mean, I think you're raising a really good point there, but that was Bill's reading the paper, so I will suggest you talk to him.
Sure. Yeah, thank you so much. I'll sit down.
I think your question is also very important, and it comes up when you are requesting a data set and then the response from, for example, the police department or DA's offices, that's just too much work, we really can't give you all of the data, then you have to get a random sample.
Mm-hmm.
And then you have to deal with measures of statistical significance and various statistical tests based on what data you are able to obtain.
But that's not most RJE situations, right? I mean, at least not the ones that we've been working on. Like we get all the data per category. I've never worked with subsample.
So, well, there are situations where you do have to get a subsample.
Thank you so much for your panel. I work with the Heafey Center, and we're in touch with thousands of people in prison. So I can tell you that we're getting numerous requests for data, right, so that people can meet the approved access stage. And so my question is, how can we get researchers to publish more of the really easy, like, this is what happened on 3 strikes in this county in this year. Like, please publish it, get it out there so that we can get it inside, so we can get people on court. And I don't know what we need to do to make that happen. So I'd love to hear from you all about what your thoughts are.
That's kind of an interesting problem with the discipline and academia in general, right? Because studies, academic journals always want like the big data sets, super fancy statistical models and stuff like that. And it's harder to publish in a top journal where you're just doing like cross tabulations, like the kind of stuff that I showed. It's really impactful, but it's not necessarily the stuff that's going to get cited in top journals, and that has something to do with the incentives in academia, and especially for like junior faculty. But I think maybe one way you can get around it is to go find like full professors and people who already have tenure and are very secure and just kind of try to give back. That might be a good audience target for your data analysis.
I think it's a great point. Sorry, Lisa. I think it's a great point, and I think I love it. I mean, I'm getting that request constantly all day long too. Is people, our clients in prison who give me this data. I'm like, I don't have enough time to get my own data. Like that. So it's a huge problem, a huge problem. The lack of ability to access appropriate data for people who need relief. Right. I think it speaks to a couple conversations that we've been having, and we need to rethink, right? We need to rethink the model in academia, right? We need to rethink that. What are we prioritizing? Because as you indicated, RJA and in merging in, this is a new world that we're living in, where all of a sudden for professors who have been studying these things for a really long time, it's now directly applicable to John Smith, who's sitting in prison, right? And so we need to rethink where are we going to prioritize? Are we going to prioritize people doing research that for their tenure, or are we going to prioritize research for people getting out of prison, right? So it's a wonderful topic. It needs to be worked on by all of us together and collectively come up with ways that we can make real data user-friendly and accessible.
And that'll be my soft pitch for nonpartisan research institutes, that incentive structures are different in that my goal is to produce research reports that have a wide appeal that people generally take as like rigorous and objective, and we want the policy impact to be big, which is part of the reason in the technical appendix of the RIPA report we broke out the racial disparities by law enforcement agency of the 15 largest ones, because we wanted people to be able to look within their own county, what do the racial disparities look like for stops, searches, enforcement, etc. The problem though is like when we start doing the more rigorous types of analyses, to do that for every outcome, for every county, for every subsample is a lot. It's not saying it can't be done, but as we partake in convenings like this, it's highly relevant to see what would be most impactful when we think about research questions in the RJA space.
And I just want to put in one other soft plug, but it's on behalf of my students' work on lawandpolicy.com. Like, they are incorporating social science and other kinds of things in there. And one of my students is working with y'all on, you know, sort of people inside's guide to habeas claims under the RJA.
So let's take one last comment from Lisa.
Oh no, I just wanted to add to that we're finding that it's very useful in as an alternative to actually publishing in a research journal, is for academics to prepare fact sheets. So, for example, we have Michael Light at the University of Wisconsin, who has a huge Corey data set that they spent years cleaning, and they said, well, what questions would it be helpful to answer? And so they took on a few and they published. They posted some of these fact sheets on their website, and Sujung mentioned that she's used them in her litigation, and a lot of people have, and so those can be extraordinarily useful.
All right, well, thank you to our amazing panel.